welcome back. So
Hey.
nice to see you.
Yeah.
And I'm just, I did the typical YouTuber thing. I started a recording instead of going live. So I've been talking to dead air for some time, but we're back now. And I am a monkey pushing buttons. I'm sorry. And I'm keeping an eye to see if they're coming back in the Rintala case and hear what they're arguing about. But we have the Karen Reed hearing. I was thinking about doing tomorrow and Saturday. If the other case come back, we'll pick it up again tomorrow. And if people are not familiar with the Karen Reed case, this is the case where she supposedly hit her her boyfriend with a car while backing out from a driveway. The defense claims that he might have went into the house of another officer. In that house, a scuffle ensued because there's some phone data suggesting he moved around or his phone moved around in the house. There's also a little bit of shenanigans with a dog that went to live on a farm. We can't say it's that because Jim is gonna cry.
I will.
And they can't really produce.
Everybody.
And they can't produce this dog because, it went to live on a farm. There's a swimming pool being filled in. There's a new floor in the basement, and they sold the house. And all the people investigating these crimes are friends with the people they are investigating because they're all officers, and the victim is a police officer as well. So there's a lot of shenanigans. And if any of you know about Turtle Boy or Turtle, I can never remember, is it Turtle Boy or Turtle Man?
Turtle Boy, yeah.
Turtle Boy. He has a lot of videos about all the funny things in this trial. His body was found covered with snow, and on top of the snow, they found the tail light from her car because allegedly she broke the tail light while hitting him. There are some videos where they try to break the tail lights of a car. It's not as easy as you would believe.
It's
And
not.
there's a lot of scratches to one of his arms that looks suspiciously like a dog has been biting and scratching him, but they say that's blunt force trauma.
I think it's from being ran over by the car, which okay.
Yeah, but let's get into it and see. This is a hearing, Fedorowski. Yes, it's just a hearing. But there's this hearing and one more hearing, and I can't. Is it October or November they're gonna do the trial? I'm sorry, I'm a bit caught up in the Kara Rintala case, so I'm not as familiar with all of the facts in this case. But we watched the first hearing where they presented all the discrepancies. I have read the statements from the officers, and they seem sus, but it could just be me reading things into it that's not real. But hey, Jungle Minx, Irish is here, Danny T is back, Fed is here, Wesley Hoke. Yeah, there was a shocker in the Whitmer case. I bet there's two people are really not happy they took a plea deal. I'm sorry, I'm getting tired. Hey, Josie, nice to see you.
Hi, guys. Hi, Irish. Josie.
Do you know what this is in Danish?
Fed?
Yeah.
No. What is it?
That's fat.
Fed? Fad? Fat?
Yeah, F-E-D. Fed.
You guys and your words.
There's the girl in love with the Boston lady saying "car Mark."
Can't say it for R's. I love that. Oh, I love when you don't pronounce an R. Ooh.
Hey, Boomer. I finally got it. Boomer.
Yeah.
I'm so stupid.
You didn't catch that?
No, I'm not talking to you, Google. I said Boomer. Jackpot back. I'm so stupid. How many times have I pulled up Boom Her and called it Boom Her in the last couple of days? Yeah, Vikings need a little fluffiness when they have to fight. It's the same when people won't write Lord, so they put a T instead of a D. That means in Danish, Lort. Lord is shit. So yeah, Boomer. Just one more try. One more try. Then the next case will be the last case. Oh, cool, roller derby. I remember watching roller derby on TV back in maybe the early 90s. That was fun.
Yeah, roller derby is pretty. It's pretty cool.
Yeah, my sister used to play roller hockey, so that was a thing back then. But I really liked the roller derby. I know it was kind of scripted like wrestling, but I like watching wrestling as well. But,
Old
yeah.
school wrestling, I loved it back in the day.
Yeah, it's getting too flippy floppy to watch now. I don't like that. But back in the day with Stone Cold and The Rock and Jake the Snake and all those people, I loved it. I remember my brother brought home a tape from, I think he had a VHS when he went to the US, VHS with WrestleMania 3, I believe it was, the one with Hogan and Andre. That was amazing to watch.
I bet it was fun.
Yeah, that was back in the day. It was pretty fun. And then when the WWE Network came out, I had that for a couple of years, but then it was just flippy floppy. There was no storytelling, so
There's
I didn't
too
like that.
like acting in it now where it's just over the top. It's not as
Yeah.
fun as it used to be when it was like Stone Cold and Rock and all them. And like D-Generation X and all them. Oh my god, I love them.
Yeah, I loved. We could view WCW on the German channels. We couldn't watch WWE. So I'm a great. I thought that Diamond Dallas Page was a great wrestler. I did his yoga for a couple of years. He has a yoga program. It's really good because it's not a spiritual and stuff like that, and he put some cool names on it, so you don't feel like it's more fun for a big guy to do when you see a wrestler do it. And it really helped me with my mobility when I started working out again. Yeah, Lefty, if we could find a way to get clips and talk about old wrestling matches and old pay-per-views, I would do that in a heartbeat.
My dad took us to one of the Sunday night heats when it was WWF, and we got the big Stone Cold Steve Austin foam hands, like the middle finger.
Yeah.
Oh my god. I don't know why my dad let us have those because we were younger and we're like sticking them out the window all the way home to people. Like, and he's like, "Oh my god, I should have threw those away." But I had that thing forever. I loved it. It was so much fun.
I never watched ECW because they weren't broadcast. Yeah, skide fed. That's cool shit.
Mm-hmm.
It means shitting fat. Yeah, we're at the rate. What's happening in this case? We're gonna have this is the second hearing. It's a motions hearing, so we're gonna hear it. I just wanted people to have a moment to filter in, so we get down the sidetrack talking about wrestling. Hey, Christine, haven't seen you all day. Rugby, never watched much of it. I don't understand the scoring system in rugby. Yeah, Sean, this is a really fishy case, especially after watching the first hearing. Maybe we change our mind watching this one.
Yeah, right. I've already looked too much into it.
No, Christine, we have watched the first hearing, and now we're going to watch the second one. We have talked about it earlier. I have a stream. You can go back and watch it where we talk about how we didn't think the scratches on his arm looked like blunt force trauma.
Mm-hmm.
But let's get into this one. I should probably boost something if I know anything, but I don't know any. Oh, maybe I should turn on audio. Look at all these again. Oh, and we can.
Who are these people supposed to be?
I don't know, but it's
'Cause I don't
filled
really
like
know who
they are
wow.
applauding when she steps. What the hell?
Go back. What was all that? Go back. Oh. People are serious about this.
Yeah, this can turn. Oh, that was Turtle Boy. That's stupid. Don't do that in court.
Yeah, I mean,
Hey, Dave.
keep it outside. Don't do it in the
Yeah,
court.
I'm not gonna be like a certain person when DUI guy made a face, because I would have done that too if I've heard the testimony. But don't applaud and don't make noises, because that's a surefire way to get thrown out of court.
Oh yeah.
Especially if it was Turtle Boy who wants to cover the case and has the ability to be in the court. Don't do stupid stuff like this, because you're gonna get thrown out.
Oh, okay. I thought it wasn't him, it was other people, other servers.
Okay. Okay, thank you so much, Wicked. Well, I have watched some of his coverage. If he has harassed people, never do that. And this is boosted audio. Hope they turn on the mics at some time. You don't harass anybody, no matter if they're wrong or right or up or down, anything. Especially families. Stay away from all that stuff. That's why you have a judicial system to take care of this.
Exactly what was still outstanding and when you thought that you would get things surrounding to the defense. So since then, we will do the motion to compel. Since that time, counsel filed additional motions. So there have been, what I understand, what I have is 2 Rule 17 motions filed by the defense, one essentially for records when you can't tell for every guy. Was that Zoom chat?
Yes, sir. I will try, sir.
Second is a motion for the Google Next over here. 3 filed by the Commonwealth, footage regarding.
I would really like them to turn up the audio.
The video footage of defendant's father's home. So whoever's on Zoom, you have to be muted or we'll throw everybody.
Okay, thank you, Wicked.
Motion for records from ABC and NBC essentially. And then you are the host of like you with your microphone. You can press star 6 to unmute. Jim, do we need to start again on something? You are unmuted. And then there's a recent motion regarding exhaustive testing. Then there's motion for me to review conditions of bail. And we're also going to set a scheduling order because these piecemeal Rule 17 motions coming in with an affidavit been in possession of counsel since January 2022. We're not going to keep doing that. We'll set firm dates. So before we start with the motion to compel, have the third-party record holders been given enough time? Have they been notified, Mr. Lilly?
So yes, with respect to each of the respective 5 entities of Commonwealth and Defense, I can send notice all the third-party subjects and all the third-party records.
Did you get any responses?
Okay, thank you so much for telling me. And Sean, I will try to cover this case as well as I can. I won't go into all the details that Turtle Boy has done, and I won't do any experiments with smashing the tail lights of my car, but I will cover the case, and I will not harass anyone. I do make fun doing the cases, but I try to let the evidence speak for themselves. I am not a guy who's gonna claim anyone is innocent or guilty. Well, everyone is innocent until proven guilty, in my opinion. But I will still try to be objective and let evidence lead my thinking. I'm not the kind of guy who's gonna be a drama trooper and yell and cry about everything. But I do make fun, so you have to be prepared for that. But I like to keep the evidence talking in cases.
Your Honor, if the court could define which of there's multiple motions, both from the side, the record holders from, or with related to Mr. Lally's motions, NBC, ABC, alarm.com. Is that what the court's talking about, or the? Right.
No, sorry, but I bet he could. Well, I'm not pro anyone. I'm just pro the rule that you have to be proven guilty.
Yep.
Good day, Luna.
I would say you have to be like, I don't know, yeah.
Not completely, as it relates to the town clerk, no issue. As it relates to Google Nest and Google, we have no issue. As it relates to NBC and ABC, I have no issue with alarm.com, but the other two motions that the Commonwealth filed Rule 17B motions on, I do have an issue with, because I don't have enough information to be able to state with any authority that they have not received consumer notice. However, in speaking with both those entities, producers at both those entities, I have not spoken directly to legal counsel on either side, but for either agency. However, I was told by individuals who had spoken to legal counsel that they had not been served. They had not received any formal paperwork from the Commonwealth as yet. And that was probably,
well, Sean,
I want to say 5 days ago.
Most of the people we screen with have.
So that's the latest
stamped.
Information I have. In other words, I don't have information that they haven't gotten
guilty.
Notice, but I certainly don't have information
I like
that they have gotten notice
when they do
either.
that. Not that when they're proven guilty, but I like to follow a case and see it evolve. Yeah, and sometimes the prosecution has a great case, and those cases can be interesting. I like good lawyering.
Yeah, if they have all the evidence.
I have a really old Steel series. I'm looking for new headphones as well, because I have a bad connection in one of them. We don't really have any good shops in my town. I'm not gonna. Yeah, I have doxed myself plenty of times, but that doesn't matter. I like these Steel series because they are kind of ventilated, and sitting here for so many hours a day, your ears sweat, and that's nasty. I think the headband is annoying. It's too tight.
That's satisfactory with us, Your Honor.
So, since you have looked, what is the quickest to resolve the town clerk motion, Mr. President? So, in reviewing that, I sort of assumed something.
Thank you for showing up, Sean B. Sarcasm. The sarcasm. Sorry, it's been a long day already. I started streaming at 5 a.m., 6 a.m.
Mm-hmm.
Hey, Ghosty.
take a close look at the order. All right, so why 116, and now we'll go to the Google Nest motion, Rule 17 motion, paper number 125. Mr. Henning, why don't you come up since this affects your client as the third party?
Yeah, we've seen a lot of
Okay.
cases where they find. the
So why
victim,
don't I hear first, I'd just like you up here, why don't I hear first from Mr. Jackson? Sorry if it makes it uncomfortable for you
They
standing
find
there.
that the
Why don't I hear-
suspect, and then
I
they
guess you'll have to
oh,
take a
that
seat. Why don't you
suspect did
just sit down?
it. They don't look
Thank
at
you.
everything.
I'm sorry, Mr. Henning. All right, Mr. Jackson, I'll hear you on your motion.
Thank you, Your Honor. There's very little question that the security camera footage capturing the interior and exterior of the Albert home, the scene of John O'Keefe's death, is evidentiary, it's relevant, it's material to the defense, and it should be material to the prosecution, I would think. It should be
I
material.
have a proposed order from the Commonwealth, so I don't know that there is that much of an opposition to
There may
this.
not be, but there may be an opposition from, sounds like Mr. Henning has some things to say as well, and so my comments are directed as much to that as it is to the Commonwealth. We've known for some time that there was a camera at the house of the Alberts, but what's truly interesting is how we know that there was a camera at the house of the Alberts on the date that John O'Keefe was killed. We know that there was a camera at the house, Your Honor, because a grand juror asked Brian Albert during the course of his testimony about the camera. It wasn't the Commonwealth that asked that question. The assistant district attorney went through 26 pages of questioning at the grand jury, a full panoply of questions surrounding the circumstances of John O'Keefe's death on January 29th, 2022, and not a single question was asked about security footage that did or did not exist at the time. A grand juror had to step in and ask that question. And that's interesting in and of itself, but this is a longtime law enforcement officer, Brian Albert.
I'm actually going to interrupt you. Mr. Lally, is there any objection from the Commonwealth?
So as it pertains to the motion being allowed, no. The only objection, and that's why the Commonwealth filed a modified proposed order, because it's seeking records from Google.
Okay, so we'll talk about the proposed order. Before I hear you, because we have so much to do this morning, Mr. Jackson, I do want to hear whether Mr. Henning is objecting to this. Come to a microphone, please, on behalf of his client. It will save us some time if we direct it to the order if there's no
I
objection.
do understand. I don't think my comments are going to be very lengthy, but there are some things that I do want to put on the record on behalf of Ms. Reed.
Okay, I'm going to ask you to have a seat. I'll hear if there's an objection, and then you can figure out what you need to say if there's no objection.
Good morning, Your Honor. Greg
Morning.
Henning on behalf of the homeowner. With the proposed order that the Commonwealth submitted in mind, that language, Mr. Albert, the homeowner, has no objection to the Rule 17.
Thank you. All right, I'll hear you now, Mr. Jackson. I don't know if you heard that. Did you hear Mr. Henning?
I think I heard him say that there was no objection.
To the proposed order from the Commonwealth.
The proposed order, the problem with the proposed order of the Commonwealth is it indicates that they believe that the information is appropriate prior to January 29th, which is in and of itself ridiculous. The whole point is to get the camera footage from the 29th, from the early morning hours of the 29th. We don't have, again, this has become a sort of a theme with the Commonwealth. They indicated they wanted to change the proposed order and literally put in the proposed order that any camera footage that we would get would stop at midnight on the 28th. We have to have the footage from the 29th. And I question whether or not that was as the Commonwealth.
Did you see number 3 of their proposed order?
Proposed order is.
I read it as it's asking for a longer period of time than you requested. It's more expansive than what you requested, Mr. Jackson.
Number 1 says activation or setup information for any Google Nest camera registered to Brian Albert or Nicole Albert prior to January 29th.
Right, that's 1. Number 3. The Commonwealth's proposed order is more expansive than the defendant's proposed order. If there's an objection to that, I'll hear you.
obviously, there's no objection to us expanding the time. We want it as expansive as possible.
I just want to make sure you have the motion. Do you only have the first page of it?
No, I've got the motion. The motion was supplied to us, again, this is the second time this has happened, when I was on a flight yesterday.
Mr. Yannetti, did you receive this?
Yes, Your Honor.
We both received it. I mean, I can read it on my phone as well as I can read it on a piece of paper. My issue is, as I indicated, I want to make sure that the proposed order extends to the early morning hours going through January 29th. As long as it does, then obviously we're on the same page, and I have no issue with the Commonwealth's proposed order. I want to make sure that, and I don't have any issue with the Commonwealth's proposed order as it relates to other Google apps, for lack of a better phrase. The activity apps, financial apps, things of that nature. That's not what we're interested in. We're interested in Google Nest data. So as long as that proposed order includes and encompasses January 29th, then we have no objection, obviously.
Mr. Lally, am I reading this wrong?
No, Your Honor. Actually, number one that Mr. Jackson was taking issue with is actually directly copied from his own proposed order. Number three is, as the court noted, a more expansive time frame that goes up until 8 p.m. because if there were to be video footage, the Commonwealth would be seeking that to expand beyond the police response and everything else that's been taken issue with over the course of this case. So the only differences between the Commonwealth's proposed order and the defendant's proposed order is, number one, excising any sort of other Google account information. Which
And I
is
think Mr. Jackson
relevant.
just said he didn't have an objection to that. All
that
right,
and expanding the time frame. That's
okay.
The only wording that was changed under number one that we have an issue with is again, we believe it shouldn't be prior to, but inclusive of January 29th, and he set up inclusive of January 29th, as well as the end of that
That's
same
Turtle Boy, Sean.
paragraph that indicates that the request is for information from any on-site activation by the residential user and not an activation that might occur at point of sale. There is no such thing as point of sale to our knowledge of a Google Nest activation system. In other words, the setup, I think that's a throwaway line, and I think it should be stricken from the order because it's confusing. There is no point of sale activation that we're aware of for Google Nest systems. But other than that, that's relatively pro forma. Sum and substance is that we get the Google Nest data. That's what we're concerned with.
All right. And you prefer that I add the expansive time frame and the
Correct.
less restrictive time frame
Correct.
that you requested?
Yes.
All right, so Mr. Clerk, you can mark this. I'm going to hold on to it because I'm going to take a look at the orders more closely, but Rule 17 is allowed, no objection from the homeowner. So thank you for coming in for that, Mr. Henning.
Why is the sound always so bad in court? I only have the judge in one ear.
For the alarm, is there an objection to that, Mr. Jackson or Mr. Yannetti or Ms. Little?
Not from the defense.
Okay,
Seems good, though.
so this is the Commonwealth's motion for records alarm 121. Did you propose an order with this, Mr. Lally or Ms. McLaughlin? Did you propose an order that maybe I don't have?
Should be an order attached. I can provide the copy with an additional.
You might have it, Jim. All right. Thank you. Thank you.
Don't say terrible Boston accents when Jamie is on stream.
I love a Boston accent. I love me a Boston accent.
Hello, greedy. I don't know why I say names weird today.
Commonwealth, do you? All right, I'll hear the Commonwealth. Do you want to start with, I have first the ABC News one. Why don't I hear you on that?
Just, it makes no difference to myself, Your Honor, but there's also another related motion to that camera.
Which is to the camera one?
Yes, from the House indictment. It's a motion to compel to preserve and
I don't-
request for order production.
I don't believe I have that. When was that filed?
Same time as all of the others.
It could, I mean, I just have copies, so it could be that it was filed there. So Jim, it's probably somewhere around 121, maybe 123. Is there an objection to this from the defense?
No.
Thank you. All right, Jim.
Just
All right,
kind of.
so why don't I hear you? It doesn't matter to me whether it's ABC or NBC that you want to start with.
You're right.
Here's an
I think we can
RBF.
take them sort of in tandem. It's essentially the same issue, the same type of factual background. Essentially, what the Commonwealth is requesting is any and all video footage, including raw or unused or unaired video footage of interviews, specifically with the defendant herself. She submitted herself to interviews with multiple news programs. The content of those interviews was sort of interwoven within a narrative story, which the Commonwealth would submit as a fair inference that there's additional footage that is available. In specific reference to the NBC, there's an indication from the broadcast that this is part of a larger program to air at a future date. These statements by the defendant, as the court is well aware, are entirely admissible. They were freely given by the defendant. In each of the respective news broadcasts, the defendant, at least in part, so some of the statements she's on her own along with the reporter, and some of the other statements she's seated at a table with counsel. So as it pertains to any of those statements, there's an exception to the hearsay rule as far as statements by a party opponent. Any statements that she makes to these outlets, she's free to make, but the Commonwealth is seeking production of those statements.
Okay, who am I going to hear from the defense?
Your Honor, at this point, we don't have an objection to Rule 17. I think I know there's going to be a subpoena.
Speak into the microphone.
Sorry. I'm thinking that microphone's going to pick us up. I apologize.
It will, just be closer to it.
Sorry about that. We don't have a principled objection to Rule 17 because it's really not our dog in the fight, as it were. In terms of ABC and NBC, if the subpoena's issue, I have every reason to believe that both NBC and ABC's legal department will take great issue with the subpoena for reasons of their own. But the defense is not taking a position on the Rule 17 at this point because it's not our fight.
Okay. All right. So
We could, yeah, that's the big problem in many cases. If you don't have the means to pay for great representation, you might as well just jump on a plea deal because you really need skillful people to get into it. That's why I like the other case I'm covering, the Kara Rintala case, because there's a great defense team in that case as well. Mm-hmm. And I even think they're doing it pro bono. But this lady had some cash, and that makes a difference. But other times, you can have all the cash in the world. We saw that in the Burgos trial. If you have a bad case, all the money in the world can't make it go away.
Mm-hmm.
do you want the opportunity to speak to legal counsel and see why they weren't represented here today, Mr. Jackson?
I would like that opportunity. It is unusual, I think. I suspect that there may have been, and I don't want to speak for the Commonwealth, they know better than we do. Both NBC and ABC are out of state. I don't know that they were served out of state.
Of course,
right?
I think the Commonwealth, yes, they're served. It's right in the pleadings.
But I'm not sure where they serve notice. I just don't know, because when I did check, both legal counsel, both offices, general counsel for NBC and ABC indicated to me through another person that works there that they had not gotten any information concerning this issue. So I would like an opportunity to check with legal counsel.
Okay, so I will.
She does have an interest in it.
I will take the motion under advisement.
What happened?
If they want to be heard, I will give you 1 week for them to give notice to this court by way of letter of legal counsel as to why they did not appear here today. And then we can see about setting up a hearing. And if your position is that you don't object to it and it's just with them, we'll set a date.
Thank you, Your Honor.
All right, so I'll do the same with both of those motions.
Yeah, and that's why if you have all the money in
Right.
the world,
Why don't
in
we
a
do the
case
motion to
that's
compel,
on
and then we'll
the
get into the exhaustive
on the edge
testing
of
motion?
going both
Is there
ways,
an objection
it
to
can
the
really
exhaustive
change it.
testing motion?
Grazie, Alexandra. I don't know
At
why
this
I
point,
made
Your
it
Honor, there
like
is.
that.
Okay, so we'll
There's some
hear the
technical
motion.
reasons,
Thank you
but
so much.
We'll do the motion to compel first.
Thank
Alexandra is the one who made my new cover.
Lexi did it? Aw,
Yeah, sweetheart.
so nice, Lexi.
And I can even say if I like something changed. So thank you so much, Alexandra. Not Lexi. She changed her name.
And
know.
so when this motion
I
was
know.
first filed, and I do appreciate, Ms. Little, that you did get it to me in a timely manner after the last hearing. I do appreciate that. And I appreciate the detail of it. So then we have the Commonwealth's response that then maybe limits some of what you have there. And then I've got your response to the Commonwealth's opposition. So I think that's where we have you focused. But has that changed at all since you filed this? I received additional statements of compliance by the Commonwealth.
I will address those today, Your Honor. There's 5 sort of outstanding categories of evidence that we still have not received. I did receive a packet of information today, but I'll go through that for the court.
Okay, go ahead. So let's do what you address in your reply.
Thank you, Your Honor. It has now been a year and a half since Ms. Reed was arraigned in Norfolk Superior Court. A year and a half, and the defense still has not been allowed to so much as look at the physical evidence that the Commonwealth has had in its possession for 21 months and has so desperately withheld from the defense out of fear of what it might show. That is unacceptable, that is unconstitutional, and that clearly violates the mandatory discovery provisions set forth in Rule 14. As I informed the court, there are 5 categories of mandatory discovery that continue to be withheld by the Commonwealth, and I'd like to go through those in turn. There are first 56 items of physical evidence that we have been unable to view, unable to independently test.
Are these the items that are at the lab for testing still?
That's correct, Your Honor. It includes all of the taillight pieces, all of Mr. O'Keefe's clothing, and all samples taken from Mr. O'Keefe's clothing and person. This is the seminal evidence in this case. Your Honor, this is not a complex legal issue. The United States Constitution, the Massachusetts Declaration of Rights, and Rule 14 all require that Ms. Reed be permitted to inspect and independently test this evidence. Rule 14 could not be more clear. Quote, the prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects at or prior to the pretrial conference. Our first pretrial conference was on August 12th, 2022. The compliance date for mandatory defense access to this physical evidence was more than a year ago. In opposing this motion, as Your Honor noted, the Commonwealth has tried to excuse its blatant discovery violations by claiming lab protocols and procedures simply won't allow us to access this evidence. But lab protocols and procedures are of no legal moment, Your Honor. They don't trump the law. In fact, Rule 14 actually contemplated that this might be an excuse that the Commonwealth gave. It specifically says it doesn't matter if the physical evidence is not in the physical, actual, tangible possession of the Commonwealth. If that evidence is in the possession of any agency who participated in investigating and evaluating the case and reports to the prosecutor, which clearly the Massachusetts State Police Lab does, then discovery is mandatory. That's Rule 14. As this court well knows, this is not the first time we've requested access to the physical evidence in this case. So when Mr. Lally stands up, as I believe he probably will, and says, we're almost done testing, the defense can have access to this in 30 days, I want to remind this court that we've been here before. Yeah. In fact, we argued this exact same issue before the court 6 months ago. And I think it's important for the court to be reminded of the representations that were made by Mr. Lally at that hearing. On February 8th of this year, Mr. Lally stood here in open court and made these promises.
That's so shady.
I did speak with the lab earlier this week, as well as last week, a couple of weeks ago, and on several different occasions. But my expectation, from what I'm told, is that their analysis and report should be complete within the next 30 to 60 days. Those were Mr. Lally's words in February. And my guess is that's what he's going to say today. But what is disturbing about those representations is that the crime lab actually keeps track of their communications with Mr. Lally. And when you review the crime lab conversation log, which was produced to us in Discovery about a month ago, this is what you see. Quote, note to file, date January 3rd, 2023. Entry by John Buello, person contacted, ADA Lally. Note, quote, emailed Commonwealth prosecutor on 11/21/2022 about the status of testing. No response back. Therefore, the trace items will not be tested at this time. If for any reason testing is needed, the items can be resubmitted to the lab for potential analysis. Trace assignment closed, no report. And what you also see is that between January 3rd, 2023, which is the date of that entry, and the date the Massachusetts State Police Lab apparently closed this case, and February 8th, which is the date that Mr. Lally stood here in court and made those representations that he was so desperately trying to expedite testing, there is not a single record of communication between Mr. Lally and the lab that's contained in
I
that
hope the
conversation
judge
log.
is going to bring the hammer
That's
down.
not Mr. Lally's hands being tied by lab protocols and lab procedures. In fact, the assignment was closed because he failed to answer his emails. That is deception, Your Honor. So when the Commonwealth stands up and says that the defense can have access to the physical evidence in 30 or 60 days, that's not good enough. We need court intervention. We need this court to order the Commonwealth immediately provide us access to these critical items of evidence and set a date for compliance, because that's what the law requires. That brings me to the
She
second
can order them to
category
do it.
of evidence that we're missing.
How you can hold them in contempt?
Your Honor, for
Yes, I
quite
don't
some
know
time,
the-
we've been asking for access to the Lexis infotainment system and the Lexis telematics system. As of this morning, our expert was able to get in touch with Trooper Garino, and they're currently working on coordinating a time to hopefully analyze that evidence. I'm hopeful that the Commonwealth will be forthcoming and allow us to obtain our own analysis. If there are any issues, we will plan to file a proposed protocol for the examination of that evidence with the court, but I'm hopeful it won't come to that.
This is, yeah. If he was on the record saying he was doing all this stuff, he was in contact with them, that's lying to the court. I really hope the judge is going to give him an earful, and hopefully,
That's pretty shocking.
yeah. One thing is you can be an asshole and tell the lab without having a paper trail. Please put this on every time something comes in. Put it in the bottom of the pile. You can do shenanigans that way, but he haven't even contacted. And when the lab contacted the police to hear what they were supposed to do, they never answered. So the case was put on hold. That's a big problem in my opinion. That is hampering the defense of the case, and you can't do that. You can do all kinds of shenanigans, but you can't lie in court and get caught in it. Well, I don't know. Again, I'm not an American lawyer. I don't know anything, but just on the face value of it, this is crazy.
Mm-hmm.
Exactly, the Koberger case as well. There's they don't want to turn over evidence, and if your evidence is as strong as you believe they are, you should be saying, "Come check it. We got everything we need to throw you away for good. But if you're hiding evidence, if you don't want to turn over electronic devices and stuff like that, to me it just seems like a cover-up and trying to drag it out. Maybe, as you mentioned earlier, you need a lot of money to run a case like this. Maybe she run out of money and can't have this crack team running her case, and then you can get a plea deal.
But like, that's hard evidence to have. Like, you know what I mean?
But me and Mass, we live in a socialist paradise, so we know that the state, they really wanted to turn it over, but they had a bad Wi-Fi connection, so they didn't get them email. So yeah, that's
To say we have this evidence that this has been closed out and you haven't tried to, woof, that's.
yeah, this is kind of interesting that they haven't even done the testing on the evidence yet.
Yeah, and he said they've been trying to.
Yeah, and that's the big problem in the government, and that's all over the world. You can only fail upwards.
The third category of evidence is the handwritten notes of law enforcement. As this court is aware, it was filed with our papers. Law enforcement was ordered to preserve all handwritten notes taken in connection with this case. That was done in Stoughton District Court on February 2nd, 2022. And I know Your Honor sort of reaffirmed that order just in passing during one of the court appearances when we asked for her to renew it. We know law enforcement took copious notes in this case because most, if not all, of the reports were drafted weeks, even months after the actual interviews or investigation took place. We're asking for the court to immediately set a compliance date for production of those notes. If the Commonwealth has nothing to produce, then we also need confirmation of that because it's in violation of a court order.
Have fun, Anna. Thank you for stopping by.
The fourth category are reports, handwritten notes, and mapping documenting the recovery of evidence from the Albert residence. This information should have been produced over a year ago. If you were to review all of the police reports in this case,
we have a local politician with the same speech pattern, and it's so annoying to listen to because they always seem like they're too emotional. It's just her way of speaking. I know that, but you can train your voice to have fun. Could probably talk about voice classes and stuff like that, because you can change the way you speak, and especially when you're a lawyer who has to be in front of court, you should work on that. Her every trial she's gonna be in, people is gonna wonder, is she's about to cry, instead of listening to what she's saying. You really have to work on still like this.
She's nervous and poor thing.
Yeah, but again, you can change it because actors do it all the time. Okay, you're still here, but thank you for being here, Nana, even if you're not in chat. And everyone, please participate in chat. Get everything out there and ask questions. I love when people are interacting.
It's
Hey,
Friday,
Genevieve.
everybody. Turn it up in chat. Turn it up. Baker loves.
I
Loves
love to see
comments and
new
questions.
stuff. Yeah, and she's arguing really well, but everyone, what did you notice? Did you notice she talked about the third or the fourth or the handwritten note? No, everyone is thinking, is she about to cry? And you can work on your speech patterns, and you really should do that. Exactly, you because you judge her by listening to her voice.
It's shaky. I mean, good God, this is like, yeah, so many people there. It's being televised. It's a little scary.
Yeah, and maybe she's angry, and maybe it's some tears coming over her. But again, they are professional. I don't know how long you have to go to school to be a lawyer. In Denmark, it takes 7 years to become a lawyer. So you have time to practice in public speaking. It's the same as when I started out being in politics. The first time I had to stand up and give a speech, it was really nerve-wracking. The first time you have to speak in front of maybe 10 people, you think, oh my God. But then you get used to it. And now being on YouTube, we are 37 people here on YouTube and a couple of people over on Rumble. I know I have a lot of accent, and I know I don't put all the words in the right order, but you have to enunciate and talk, because you can't just sit here like this, because then everyone would leave because they get annoyed. And it's the same as with a lawyer. You have to captivate the jury. Randover. Am I right, Jamie?
Yes, good job.
Gracias mille.
Yeah.
Gracias
As
mille.
we've done, then you might mistakenly believe that there were only 2 searches of the lawn of 34 Fairview Road that resulted in the recovery of taillight pieces. Those searches were on January 29th at
Welcome.
5:45 p.m.
If you can record yourself talking about a car, Jamie would love it. She loves a Bostonian accent. But so glad to have you here.
by the search team. And there was a second search on February 3rd, 2022. But those reports are not complete because according to photographs of the evidence bags in this case, which we just received on July 25th, Trooper Proctor claims to have actually recovered taillight pieces over the course of 5 additional undocumented searches of the Albert residence throughout the month of February. The only reason we even know about these searches is because when Trooper Proctor logged these pieces into evidence, he had to write his name, the date, and the place those pieces of taillight were supposedly found, 34 Fairview. That's 5 undocumented searches, Your Honor. We don't have a police report for any of those. No notes, no reports, no photographs of where those taillight pieces were found in the yard. No memorialization of the individuals who called Trooper Proctor to the scene. That is not acceptable. If this information exists, we're entitled to it. We need a short compliance date for the production of these notes and reports so that we can at least attempt to prevent further fabrication of evidence. The 5th category of evidence, Your Honor, is the raw data associated with the CERT team search on January 29th at 5:45 p.m. We received a disc this morning from Mr. Lally. I obviously have not had a chance to review that yet, so I don't know what's actually contained on it. This has become somewhat of a pattern in this case. So I'm hopeful that everything's on there, but I'm not able to guarantee that for the court. He also indicated that there are additional materials that are forthcoming. Obviously, we haven't received those yet. I'm asking the court to set a compliance date to make sure that we actually get the information that we've requested.
Okay, thank you. Mr. Lally?
Oof. Your Honor, I'm not quite done.
Oh, you said there were 5.
I was going to have a conclusion if I
Okay.
finish addressing the court. Thank
Sure.
you. Your Honor, we are entitled to this discovery and we need compliance deadlines. Ms. Reed has a constitutional right to a speedy trial and to prepare and present her defense. The law is clear that Ms. Reed was supposed to have access to all of the requested information in August of last year. Respectfully, Your Honor, we're asking you to please enforce these rules and get Ms. Reed the discovery that she's entitled to. Thank you.
Thank you. Carmel?
So this is the father of Karen Reed.
He is
Probably
so cute.
this is the mother, I presume. Do you know that, Gladys? If it's the mother or
Is it like or maybe your mother? I don't know. She looks a little younger, but she could be the mom.
yeah, she could be men can remarried. So can women. I don't know why I say men can be remarried. But nice of them to be in court. And but did you hear that? More than a year since they were supposed to have the evidence.
Yeah.
It was supposed to be August last year.
I'm like stunned.
Hey, Paige.
Hi, Paige. How are you, sweetheart? Aw.
That's. I thought this case was fishy before. When I read about it, then I watched the first hearing about the blunt force trauma, and then I thought this is so suspicious. What's going on in this case?
Mm-hmm.
And they got ordered to deliver on the evidence in the last hearing, and now they haven't done anything still.
And according to those notes, they haven't done anything since what, January?
January 8th, I believe it was.
Yeah.
And no, he claimed at February 8th
He
was in
claimed
contact.
February, but the
Yeah.
notes say different.
Yeah, it was the middle of January. The lab tried to contact them, and no one ever got back to them. So they just filed it under "don't do anything."
That's crazy.
That's annoying. That again, you can do shenanigans, you can let stuff slip in the button, but you can't do stuff. I'm sorry.
Mm-hmm.
Yeah, sure.
I've sent her a link. I'm not sure if she's
Most of what I
covering the
believe was
California
just
case.
addressed was dealt with in the Commonwealth's response.
Sure, he's speaking in a microphone right in front of him, but if you can't hear him, can you go over to the podium, please?
That's fine. So, Your Honor, I believe most of this I've addressed in the Commonwealth's response, and just to be clear, it's not an opposition to the defendant's motion. The Commonwealth is well aware of its discovery obligations under Rule 14. It does not oppose the defendant having access to these items. It's merely an issue of timing. Now, as it pertains to the first enumerated item, and there's been various modifications of this, and what I would say is that the Commonwealth is very aware of its ongoing obligations under Rule 14A1A, under Rule 14A4, as it pertains to mandatory reciprocal discovery and exculpatory evidence, and has provided counsel for the defendant with, we're close to 300 items of discovery at this point. So this is not a situation in which the Commonwealth is, I would submit, withholding evidence or preventing the defendant from receiving any discovery. As soon as the Commonwealth receives it, it's provided to counsel. There was somewhat of an issue at some point over the history of this case where I had been providing discovery to Mr. Yannetti that apparently wasn't making its way to either Ms. Little or Mr. Jackson. My remedy for that has been to provide whatever I can, especially documentary evidence and attachments and email, so that it goes to all counsel and all counsel have access to it, which caused some of the delay as far as the testing in the lab is concerned in the first place. The lab was prepared to conduct its initial DNA testing back in May, had to wait until July, and then there was a second subsequent exhaustive testing, which wasn't conducted until August 1st because of the timing in which we received the exhaustive authorization form from counsel. What I can say is Ms. Little and Mr. Jackson were very good as far as soon as they were made aware of the issue, they executed the forms. I received them, forwarded them to the lab the same day. But unfortunately, all of the DNA testing was not able to be completed on that July date because of how late we received that particular assignment. As far as the items that are contained at the lab, again, these are the lab's policies. They're not my policies. There's nothing as far as anything that the district attorney's office or myself has done, any suggestion that we're desperately withholding evidence from the defense as we're afraid of what it might show is just patently ridiculous. The items that are at the lab there's no objection to counsel swabbing anything from any of those samples, inspecting them, photographing them, doing whatever they would like with them. The issue is when the lab is done. And as I detailed in the motion, there was a recent trace assignment that was completed, not recent, but several months ago, actually. And it had to do with item 3-1 and several other items pertaining to the taillight. And so 3-1 is the passenger side rear tail light of the defendant's SUV. Items 7-5, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 19 were all pieces that were recovered from the area where Mr. O'Keefe's body was discovered in front of 34 Fairview Road. Now, each of those were subject to a comparison analysis in which they were essentially fitted back together with item 3-1, which was the actual units from the defendant's SUV. That was believed to be done. So the lab at that point had made a forensic link and was believed to have been done with testing related to that. Subsequent to that, there was a subsequent discovery based on some additional testing in relation to item 7-18.18. And that essentially was microscopic pieces. And when I say microscopic, they measure approximately, probably less than 1/16 of an inch of clear and red plastic pieces that were recovered from the victim, Mr. O'Keefe's clothing, specifically his shirt. Based on that discovery or analysis, there was then a subsequent trace assignment that was created in relation to comparative testing for those microscopic pieces to item 3-1. Again, an item that the lab had theretofore thought that they were had completed with. There's also an
Eliza, if you're new to it, we have covered the previous hearing, and again, I'm not saying anyone is better, worse than anyone. I always start out with the presumption of innocence, which is the rule in almost all court system. It's always the state's obligation to prove her guilty. What we have seen in this trial, and he's doing it again now, he's claiming that they really want to comply, but the defense just doesn't comply with them. They don't work with them. They really want to turn all the evidence, but the lab has a little problem. They really want to give them all the evidence, but it's just because the defense didn't sign the motion. That's the excuse we heard in the first one. And then the judge said, get to it. And now we're here half a year later, and we're still going. So I presume her innocent. I haven't looked into her backstory. I know when I read the testimony about it, some people talked about arguments, some people talked about her being kind of a bee. But still, in my opinion, and what I like to do on my channel is watch the cases with the presumption of innocence. Even people who are complete dirtbags, I don't like. It's still the state's duty to prove them guilty. It's not their duty to prove themselves innocent. So I haven't looked into her backstory. I know a lot of people in the circles they ran around in didn't like her because she was kind of a snooty college girl. I think she's a professor or something. So a lot of people didn't like her, but still, that doesn't change that I don't like that the state isn't complying with orders from the court and isn't working with the defense, and still try to blame the defense that they really wanted to do all the stuff the defense asked, but the defense just, last time it wasn't, they didn't sign the piece of paper. And now he said, well, we had communications, but it just didn't hit go to the right people. So, but still, if you don't like her, and if you think that the prosecution is presenting some good arguments, please write it in chat, because I'm here to learn just as well as everyone else is. So I welcome every and all opinions, even the ones who are saying, well, she's guilty, throw away the key. It's okay. Maybe we can watch the trial and you can convince me, or I can convince you, or the evidence can convince both of us. I welcome all opinions and all people, as long as you don't attack each other in the chat. Every opinion is just as valid, in my opinion.
Mm-hmm. I agree.
That's kind of makes sense. And Eliza, again, even the Bradley Young case, one of the cases where I really wanted to reach through the monitor and beat a guy, he still has to be proven guilty. And believe you me, I didn't like that guy.
Oh, yeah.
And yeah, and you can get your information from 100 different sources, but that's why I like to watch the trials live, because then we can see what evidence is presented. Because when I cover it, or Turtle Boy or CNN cover it, we also have our prejudices, and that's why when you're watching a trial, the evidence should tell you what happened.
Ongoing trace assignment for comparative purposes to some glass that was recovered from the rear bumper of the defendant's vehicle, comparing it to pieces of what they describe in the lab notes as cocktail glass that's found on the ground near Mr. O'Keefe and near Mr. O'Keefe's shoe. Of note, what I would say is that Mr. O'Keefe is observed leaving the Waterfall Bar last time that he's on video, carrying a short cocktail glass in his right hand as he's leaving from that facility. So that trace assignment is open. The DNA results from the July testing has been completed and provided to counsel. The DNA testing results from the August 1st testing, my understanding, should be completed. And again, these are not promises that I make. These are estimations based on what the lab can tell me as far as their expectation of when items will be completed. But the DNA testing, I anticipate, should be completed on or around September 26th. Those 2 trace assignments should be completed sometime in the last week of October. And there is additional DNA testing that has just been scheduled to be undergone shortly. The
Crock of BS.
as far as whatever the court deems appropriate to impose, obviously the Commonwealth will comply with that. We'll make arrangements with the lab. They do not allow outside personnel into the lab, so it'll be a situation where obviously items that are currently undergoing testing are not going to be taken back from the lab, but if there are any items that have no forensic value left to the lab, once this sort of round of testing is completed, we will certainly pick those items up and make them available for counsel. But
Do you anticipate that this will be the last round of testing for DNA?
Eliza, yeah, I know you are around the free segment, and it's not. I wasn't only talking to you. I know you are one of the persons who can watch a case from different sides. But there are 38 people here, and if some people are new here, they can be because Karen Reed is getting a lot of attention right now. I just wanted to talk about what my channel is about. I have seen you before. I know that you are on the right side in the Zachariah Anderson case. A case, if you haven't heard about it, everyone go check it out. That was an injustice that was done in that case. But I wasn't specifically talking to you when I talked about what happens on this trend. But again, every opinion, every person is A-okay as long as you keep a nice and not clean chat, because Lefty gets in here sometimes. But have fun and believe you me, I've been doing this for trial stuff for a couple of months now. I have some of the nicest muffin tops chatting in the chat.
Yes.
I anticipate it will, but at the same time, it depends on what the other testing shows. So it's typically what the lab is going to do is they're going to test until they get a forensic link, or either they do or they don't. But basically, so without knowing what the results of the testing that's just undergone or is just about to be undergone or is undergoing currently, I can't speak to as to what those results would be, and therefore I can't speak to whether or not there would be any need for additional testing.
Okay.
As it relates to the Lexus infotainment and telematics, I'm just a little confused because initially how it's phrased in the motion that compels, it's sort of incorporating all kinds of different materials. So it's talking about an ACM, EDR, LSS. Now the ACM is the airbag control module in the car. EDR is the event data recorder. LSS is the Lexus safety system that's specific to a Lexus. All of those items are in the vehicle. And I've endeavored to arrange, should counsel have an expert that wishes to view or download that material directly from the vehicle themselves, all of that material, including the raw data, has already been provided to counsel. Way back in May of 2022, Mr. Yannetti had retained a reconstruction expert who had actually gone to the vehicle and downloaded the ACM material. So I'm just What I was told most recently is that they don't need to look at the car, or they don't want to meet with Trooper Paul from the cars unit to do anything with the car. As far as it pertains to the Burla and the telematics, as I've stated previously to Your Honor in court, the issue is, and just for the court's understanding, the Burla is, think of the Burla as a Celebrite for an infotainment system. So it's essentially the software that downloads it. The issue is that Burla, which is essentially really at least the only certified forensic tool that I'm aware of that pertains to those types of systems, they receive updates periodically from the manufacturer. I believe there's another one coming up in a month or so. But I have no information. We reached out to Burla numerous times, but I don't have any information as to whether or not this make and model of a Lexus is going to be part of that update that they provide. But up and until we receive an update that can actually read and parse the data that's contained therein, it's an issue as far as, you know, there has been data that we've extracted and we provided to counsel, but it's essentially unreadable data at this point. I am aware that Trooper Garino from our office spoke with counsel's expert yesterday, actually, in regard to seeing what can be done, what had been discussed, and what I had discussed and discussed in the Commonwealth's response is what's called a chip-off. Now, a chip-off is something that doesn't just pertain to the Burla or to the infotainment system. It also would apply to an event data recorder. It's the issue with the chip-off is that it can be and likely would be destructive. So essentially what it involves is sort of burning the chip off of the unit. And in that process, sort of inherently within that, can be destructive to whatever data or material is in there. And you don't know that until you've already completed the process and started to look at it. And that is the reason that the Commonwealth has not endeavored to do that at this point and has opted to wait and see sort of if we can get an update from Burla or from the manufacturer to Burla so that we can read and parse the data. If that is something that counsel is interested in doing, again, I spoke to Ms. Little a little bit about this, that the Commonwealth certainly is not going to conduct any of that testing without them having an expert present to do any sort of chip-off or any kind of destructive testing whatsoever. But if that is something that counsel is interested in, I would encourage counsel to file a motion with the court, as would be done with any sort of destructive testing. And if that's something that the court orders us to do, obviously we will be present, and counsel will have an opportunity to be present with an expert as well. The third category, I believe Ms. Little was referring to notes of law enforcement. Absolutely no issue with that. It's been requested. I should have those in a short frame. If the court wants to order their production within, say, 2 weeks, that's absolutely fine. Reports, notes, and mapping from the CERT team. Again, these are items. What Ms. Little was referring to today is a GPX file that I just received yesterday from the CERT team, and that's why I'm providing it today. Obviously, sending it in the mail wouldn't do as good as handing it to Ms. Little today. But essentially, what I put on that disk is a GPX file, and it's a file that contains data that can only be opened in a mapping software. So in addition to the GPX file, I also put some mapping software onto the disk to make it readable. If counsel wishes to use a separate software application, obviously they're free to do so.
When do you expect to be able to do all that?
So that was provided today. The other part, as far as notes from the CERT team, there are no notes from the CERT team. I spoke to Lieutenant O'Hara from that unit. There are no notes. They have reports, they have diagrams, they have the mapping raw data. The only thing that I'm currently waiting on and should have in the next 2 days or so is in relation to, I don't even know if they asked for it, but it's something that I was looking for as far as dispatch logs and ALV data as far as when they were dispatched and when they arrived at 34 Fairview Road, all of which should be logged. Similar to items that's been previously provided in regard to the Norfolk County detective units. As it pertains to Trooper Proctor, 5 undocumented searches of the residence, I don't believe that those occurred. I will certainly look into that, and if there is any documentation related to those, whether they be notes, whether they be photographs, whether they be reports, again, the Commonwealth has no issue providing those in short order. That's something that I've heard of the first time today.
Okay.
Sorry.
No,
This
like,
is exactly the same speech he gave at the last hearing. The defense never told us they wanted anything, and we really want to comply with. They can just file a motion. We're going to do it. Oh, and evidence will be destroyed if we try to do anything without. You had more than a year. This is a high-profile case. It's a cop killer case. Cop killer cases go right on top of the pile. I like Turtle Boy's face in this picture. For those of you who don't know it, this is Turtle Boy. He has done a lot of coverage, some good, some bad, I'm told. I've seen some of it. I haven't seen all of it, so I can't talk to how good or bad it is. But I like the things I have seen so far. But if he has been harassing people, I don't condone any of that. But talking about, it's exactly the same. It's the same guy, and he's saying exactly the same things as in the previous hearing.
I know.
Oh, we really want to help them. Just sign the papers. Let's do the thing. Oh, if you want to destroy evidence, let's destroy evidence.
They've been waiting for over a year. What are you doing?
Yeah. Exactly. Everything this man is saying is bullshit. It seems like this is not as strong as evidence as they had. And how long does it take to test DNA? They were told in February. He said in February, oh, we were in contact with them and they would get right on it. I think the longest time I heard of DNA evidence takes like 14 days to get a result. That's a lot of 14 days gone since February.
Mm-hmm.
Yeah, and no, they haven't withheld any evidence. They really want to give them the evidence, but this stupid lab just can't get their fingers out. It's the prosecution really, really wants to get this done because everyone needs their day in court and have the right to the defense. And the defense could just sign the papers, could just send an expert to watch everything, could just this case. It's annoying me. I'm sorry. So
I have a feeling they're going to test this evidence into oblivion and they're never going to get it.
Yeah, back in the days, it took a really long time. But again, this happened over a year ago. It was last winter. The previous winter, this happened. And they still haven't been able to test DNA. Even a backed up lab would have been able to do that now. I'm sorry, and I know I might be coming off as prosecuting hating, but we heard the exact same song in the last hearing.
We're entitled to it because this is basically like court. We're hearing both sides, and it sounds like they're being shady.
Yeah. And again, when he's crying the same song about we do everything. We really want, let us help. And how soon do you believe, yeah, it's going to be a couple of days. He said the same thing at the last hearing.
Mm-hmm.
They're getting right on it. Right on it. Please believe us, Judge. Nothing is going to happen. Yeah, but again, not to diminish your loss, and I'm sorry for your loss.
Yeah, Danny,
this
sorry.
is a police officer. A police officer who was killed allegedly by his girlfriend. Police officers tend to go on top of the pile in everything. That's why you don't mess with police officers, because you end up in the crosshair of every police officer. But they don't seem to be really eager to get this lady to jail. And she is out on bail, as far as I know. So luckily, she's not rotting in a prison cell. But again, she has the means to be on bail. She has the means to have a great defense team. Imagine Johnny No Name with a public defender
Yeah.
who hasn't got any money. Exactly, Cheryl. And he sounded just like that 6 months ago. Oh, when was the last hearing? That was in June, I believe.
Yeah, it wasn't that cool, but same old song and dance.
Yeah, and as Online said, because so many people are talking about all the shenanigans, there's a lot of people online too who's talking about it. And as I forgot the name, as Gladys is saying, a lot of people is showing support for her. I would do everything to cross the T's, dot the I's, but get everything out front and say, we're complying with everything. We have a super strong case. And the way they acted the last time with how many police officers were in the courtroom, 40 people or something like that, just to intimidate. In my opinion, I don't know if, of course, police will never do that, but it seemed like an intimidation tactics. They had 3 guys standing in the aisle. It was, yeah. Yeah, they're really it more and more seems like they are looking for the needle in the haystack that can prove anything. And this stupid cocktail glass, they're mentioning it again. I'm so sad I didn't have the cocktail glass ready.
Why? You gotta keep that one on backup.
Yeah, I need that for when the trial goes on. But no, this case, I'm getting angry watching it.
While I was sitting here in court. Now, I believe the 5th thing pertains to the raw data, which again, the Commonwealth provided this morning. So
This morning.
as it pertains to this or any discovery, there's been a number of other discovery items that Ms. Little and I have had conversations in regard to over the last several months, over the last however long it's been. But I would submit that when I'm asked of things, asked for discovery, formally, informally, whether by formal motion or not, the Commonwealth has no issue with continuing to abide by its duties and obligations under Rule 14. Whatever discovery I have or whatever discovery that I can provide, I'm happy to do so. That is.
Okay, Ms. Little, any follow-up with that?
Mr. Lally just listed a lot of lab work that has been done in terms of DNA testing. I just want to clarify for the court. I did review his opposition. There are only 2 items that are still subject to comparative testing. So we're asking that the rest of the items of evidence be made available to us immediately. There's no reason to continue to withhold those from the defense. As to the Lexus infotainment system and the telematics system and the EDR, as Your Honor can imagine, it's quite expensive to fly an expert from out of state to go look and interpret this data. We're trying to avoid having to do multiple trips of that. So while I understand the airbag control module and the EDR, which we already do have the data from them, are generally available, we're not going to have our expert fly out to do that until she can actually look at the stuff that's of substance, which is the infotainment and telematics system. As far as that's concerned, I know Mr. Lally has made representations to this court that the infotainment and telematics system have no recoverable data and have been hooked up to Burla. But Burla is just that. It's like Celebrate. There are hundreds of other softwares out there that are able to read and parse this data. Our expert is aware of what those programs are. She would like to be able to analyze the data. She believes that there's likely ways to do it that are non-destructive. She has reached out to Trooper Garino to inform him of this. He seems to be receptive to doing that.
Okay.
She won't know until she actually looks at it what particular softwares will be appropriate. We haven't been able to get that information from the Commonwealth because the actual photographs and things she needs to look at to see how to analyze the data, we still have not received from the Commonwealth.
So you say that your expert is talking to the Commonwealth's expert today or yesterday?
Yes, I believe actually this morning is when I
Okay,
received
so
the
after they talk, if you put in writing to me a protocol that you say your expert says there's hundreds of other methods of being able to read this data, put something in writing. It sounds like the two experts should be able to work it out, but if not, we'll deal with that. But I do want to know about that.
That's my hope. Thank you, Your Honor. With regard to the,
Wallström, nice to see you. I talked about it earlier when she presented it. If you're going to present things in front of others, you really have to work on the tone you're presenting things with. You can take classes. This is annoying to everyone to listen to that. She sounds emotional. That's not great for a lawyer. And I know you can do voice training classes. And if she's a lawyer in a case like this, she might have enough money to buy a course.
5 undocumented searches, we don't have reports on those. Like I said, we have photographs of the evidence bag that shows that taillight pieces were not put into evidence until late February. There were 5 undocumented searches. They came from somewhere. So we need reports on those. And with that, I will submit, Your Honor.
Mr. Lally, earlier when you talked about the DNA, you said that on 9/26, one item, the testing should be complete, the other, the last week in October, and then you said the third, you were looking for a date, but I think you said soon. Do you know when whatever the third part is that you were talking about?
So to be clear, the 9/26 date was in reference to the DNA work that was completed on August 1st.
Yes.
That was the second round of exhaustive testing in which their expert, Mr. Lakin, was present. That we had to delay because of first his availability and second not having the exhaustive testing form completed. The second that I was referring to in late October is in regard to 2 separate trace comparison analysis. That's sort of the estimated time of those reports completion. And then there is a subsequent 8 items that have been selected by the lab. And just to be clear, these are items that are selected by the lab, not by our office, for DNA testing. That has just, they don't require exhaustive testing. So that has just begun to be, that I think it's scheduled within the next week or two to undergo that testing. And then just my own sort of estimate as far as typical turnaround time for DNA, in which, it has been communicated to the lab on numerous occasions. Every single bit of testing that's been done, as per the court's suggestion and direction, I've requested expedited analysis with regard to each of those. So that I would expect probably around the same time frame, late October, early November, as the trace comparison.
All right. So what I'm going to do is I'm going to order expedited testing on those 8 items that have not yet been tested. And I want the Commonwealth to be able to report back in the beginning of November the results of all of the testing that's been completed. And if it's not completed, why, and when you expect it to be completed. Why don't we have all of that by November 3rd? For B, the defendant's request number 4, for the infotainment, I do want the 2 experts to talk. I need more information on this. If it's something that there is other software that can read this, then we can move quickly with it. So I need to get that from you, Ms. Little. You need to talk to the Commonwealth, your expert.
Well, they really, really, really wanted it done earlier, but unfortunately, there was a power out in the chicken coop of one of the lab technicians, so they forgot they had to do it. But now, this time, we promise you, now it's going to be okay. He said the exact same things in the last hearing. Yep. I suspect they will be getting on it right away. It's unfortunately, last time it was because the defense haven't signed a piece of paper, which the defense had clearly said, go ahead with it. I'm really annoyed about this. I'm sorry.
It is annoying.
Oh, the case is not going on till next year. But hopefully, me and Jamie will be around when it goes live, and then we might cover it.
Maybe.
So I can hang out with Jamie some more. Yeah, I hate it when the dog eats my DNA samples.
That's what I feel like is going to happen.
Yeah, but they had an accident, and they really have to retry it all again. And and the lab picked out several more tests they need to make. It's a coincidence. It's a coincidence. Yeah, and if she is innocent, I don't know how it is in the U.S. if you could get a whole lot of money for being on trial for this long. March.
Matt.
Yeah, Jamie is so young; she will be alive before the lab is done.
Let's need to talk, and you need to put something in writing for me on that. Stand up so at the microphone so I can hear you.
Can we have a
Sorry, what did you say?
Are they saying that you might not be? I'll still
Yeah.
be around, but you won't.
I'm an old guy. I can smell the dirt from my feet, so Father Time is running around my house.
compliance date for discovery from the Commonwealth so we can get the reports and the photographs we've been asking for so that our expert can make that analysis? She needs to know exactly what's in the car and have pictures of the circuitry.
Your Honor, if I could just speak to that. So the photos are on a disc and in the papers that I handed to Ms. Little this morning. Also, when I spoke to Trooper Garino, he indicated that following his conversation with Ms. Gaffney, who was the defendant's expert, yesterday afternoon, that he had forwarded an email with each of those photographs to Ms. Gaffney directly.
Okay, so if you talk to her today, if she still needs them, put them in writing and we'll order them to be produced. All right, so the request D, is the Office of the Medical Examiner, is that all taken care of? The original death certificate? You didn't raise that this morning, Ms. Little?
Yes,
So-
Your Honor.
Okay, so request number 5 is all set?
Yes, Your Honor.
Okay, so regarding the request for all of those notes, a 2-week date. So let's get that by the 29th of September. I'll give you the same time frame to see about whether there are any photographs, handwritten notes, mapping, documenting the recovery, the 5 undocumented searches that are outlined in E of the defendant's response, reply to the Commonwealth's response. So 2-week date for that, 2 Commonwealth 929. The Commonwealth says that there is no raw data with the CERT team or no notes. Why don't you just tie up all loose ends and put that in writing, Mr. Lally, by 9/29.
Yes, Your Honor.
Okay.
Thank you, Your Honor.
Okay.
Um,
That was the whole purpose of today's hearing, was to be able to do that. So at least we've got that done. Now we move on to the Commonwealth's motion for an order regarding expedited testing. And the Commonwealth has
You'll need
asked
to
me, I
agree.
believe, to impound the results here, Mr. Lally?
As far as the attachments to the motion, yes.
Yes, okay. Is there any objection to that from the defense?
No genitals. This is not the socks and sleeve lady. The socks and sleeve lady is. I have so many ongoing cases.
Corey Richards.
Corey Richards. She's out of Utah. It's where the sister of the deceased told that they would no longer be wondering when he showed up at family gatherings without socks or sleeves because he might have had an emergency on the way over there. Yeah, that's in the court record that her brother had toilet breaks with his sleeves and socks. So
Oh my God.
this is the one where she apparently backed into her husband while he was bent over holding a cocktail glass and smashed the right rear stoplight of the car, which was magically found multiple times later on top of the snow that covered his body, as you do. and where he had the scratch marks on his arms that was blunt force trauma.
Let me have just a moment ago.
Yes, he needs to post the drawing for everybody, but I don't know if he has it.
Oh,
Your Honor, I'm sorry. Did you say expedited testing or were you referring to exhaustive testing? Is that what you're asking?
Exhaustive testing, the Commonwealth's
Okay.
motion.
it might be in Discord.
I'll let you address that.
I'm not.
So, okay.
Your Honor, there is an objection.
Okay, so let me hear the Commonwealth end of the
Fine.
motion, then I'll hear your
That's fine.
objections. My question was simply on the impounding of the attachments. There's an objection to the impounding of the attachments?
No.
Okay, that was that question. I'll let you be heard on the motion, Mr. Jackson, but I'll hear from the Commonwealth first. And Mr. Clerk, the results that are attached here, Commonwealth satisfied me that they qualify for impoundment, and I will impound them.
Yes, Your Honor. Duration of trial.
Yes, I'll put that in here. All right. So Ally, I'll hear you on the exhaustive testing motion.
Yes, Your Honor. So very simply put, there is two items that, as I just referenced earlier, had been subject to DNA testing in July
Cindy.
of this year. Among those items was the root end of a hair, item 3-6.1 from item 3-6, which was a hair that was recovered from the rear bumper of the defendant's vehicle. The testing that the Commonwealth is requesting would surely be exhaustive based on the size of the sample. The MSPCL, the State Police Lab, does not have the ability to conduct mitochondrial DNA testing or the testing that the Commonwealth is requesting be done in this case. We've identified an external vendor. This item was initially marked by the State Police Lab for an external vendor because of that reason, because of the size of essentially what is the shaft ends of the hair. For those reasons, the Commonwealth is requesting that it be permitted to send it to Bodie Technologies.
Sorry?
The testing of hair, really?
Yeah.
And that's, oh my God.
It takes a long time.
But
You should know
also,
this.
hair testing is not all that 100%. So just saying. But anyways.
No, and it's his car. That hair could have been there
And
for a long
yes,
time.
that's what I'm saying. They were together. Hair could get everywhere. You know how many times I find my hair in places that you're like, why is there hair over there? How is that possible?
I don't know. I just know that, yeah, it's a total coincidence.
In Virginia, which is a lab that the Commonwealth and Defense routinely use. I don't think there's any question as to the ability of the lab to do said testing. I've also attached as Exhibit C, reached out to Bodie just because obviously, whereas it would be exhaustive testing, we were curious, or I was curious as to whatever their policy was regarding observation of testing procedures. They do somewhat allow for it, but it's more of sort of behind glass. And
It was helpful to me to be able to read it.
so for those reasons, whatever, I mean, that is something I think that is up to the defendant through her counsel as far as how she wishes to exercise that. And I'm sure whatever their choice is can be arranged with the lab. But whereas the testing is exhaustive and it would be sent to an external vendor, I felt that a court order was appropriate in order to, prior to sending that sample off and conducting that testing.
So you are not asking that I impound Exhibit C?
It certainly doesn't have to be. I just did it as A, B, and
No,
C.
the only thing that requires is A and B, so I'm only impounding A and B.
That's fine.
All right. All right, now I'll hear you, Mr. Jackson, on your opposition.
Well, they're really trying to help
Thank
them.
you, Your Honor. As it pertains to the hair, the history of that hair is somewhat tortured. The Commonwealth has been trading on the argument in front of this court and in arguments, both oral arguments and motions that they've propounded or filed, that this
Sorry for those who are new here, but I'm kind of stupid, so I kind of sometimes make drawings of what I hear in court. And when we heard this motion, when they talked about how he got, how he was unalived, this was the artist rendition I came up with. Because allegedly she backed into this guy holding a cocktail glass, and this cocktail glass was the one that gave him the striations on the arm, even though it's blunt force trauma. So yeah, I'm sorry if you're new here, but I'm kind of stupid, so I do stuff like this to entertain myself and Jamie. And this is how I believed the accident happened.
And he already has a some kind of break in his thigh.
Yeah.
I love that his legs go like this.
Well, he had to get real down low to smash into the... It doesn't make sense, especially when you draw it out.
Well, yeah, when you draw this stuff out, then it's clear. It's like, okay, this is stupid.
Yeah.
Oh my God.
Well, luckily there's no jury here today because this is just a hearing. But when this is going before court, there could be a lot of torture. Yeah, they have, but I think he had some mark on the forehead, and to break the rear glass of a car, it's not that easy. So it doesn't make sense.
Yeah, it's really difficult.
Yeah, because they found a bit of the cocktail glass on the bumper allegedly.
Now I want you and Volstrom to
have a draw off.
Pictionary together.
Yeah. Volstrom, we're going to cover a case together and see who can make the most childish drawings. I'm sorry to all your new folks. I'm really appreciative of all the new people here. We're 47 here right now. Please do all the YouTube things. I'm not a good grifter, as you say, and I'm not a good painter either.
Item that was found on the back bumper on 3-6, which is 3-6.1, is in fact a human hair. They've gone so far as to suggest the relevance of that item is it's not just a human hair, it's John O'Keefe's hair, which would establish some sort of physical evidence that my client is, it inculpates my client. Except when we demanded that the hair be tested under the watchful eye of one of our own experts, which we had not had the advantage of doing at any time prior, it turns out that it wasn't a human hair. On August 25th, 2023, there was DNA testing done on 3-6.1, and the analysis resulted in, quote, no human DNA detected. STR analysis not performed. I'm holding the DNA results. So after a year and a half, so 19 months or so of saying this was a human hair on the back of that bumper, turns out it's not a hair. And DNA testing indicated it was not a hair. And now the Commonwealth seems to be in some sort of triage mode to try to figure out how they made a mistake. And the mistake is, actually, I question whether or not it was a mistake, because you can make a mistake once. I don't know that you can do it 4 separate times. In 4 different filings before this court, 4 separate times after August 25th, after they had this document in their hand, which the highlighted portion says, no human DNA detected. They filed motions with the following phraseology. Quote, the hair has been forensically confirmed to be a human hair, end quote. Not once, not twice, 4 separate times. And the last time was just this past week when they filed something in front of the Court of Appeal with that exact same phrase. The hair has been forensically confirmed to be a human hair. Your Honor, at some point, that's not a mistake. That's a deception. That's a knowing fabrication. That's a lie. And I don't use that word lightly. I'd love to consider this conduct feckless and irresponsible, but it's not. To do this 4 times, this is pernicious, and it's intentional. So when the Commonwealth comes to us at the 11th hour and says, oh my goodness, hang on a second, let's all take a time out. We want to destroy the very item that we've been trading on falsely for 18 months to do mitochondrial DNA testing, which would, as Mr. Lally indicates, he's smart enough to know, the lab is smart enough to know that's completely destructive testing. That will be exhausted, it's gone after the mitochondrial DNA is done. I expect that Mr. Lally will say something along the lines of, well, we were just trading on the idea that Maureen Hartnett at our crime lab microscopically confirmed that it was a human hair. And she did. What's the problem with that? She failed her proficiency exam the month before she did the examination on the exact same issue. On the exact, and it's not like a generalized proficiency exam. It's a proficiency exam dedicated or focused on whether or not she can microscopically determine a human hair. And she failed that. So they have Maureen Hartnett saying it's a human hair. She's not even qualified to say it. Then they go back and DNA test it. It comes back not to be a human hair. Then they say we want to destroy it. My position is it should not be destructively tested, certainly not by the Commonwealth. I understand, I know the Bodie outfit in Virginia, the third-party outfit. They've got a good reputation. However, before anybody gets their hands on that hair, I don't even know if it is a hair, quite frankly. Before they get their hands on that item and destroy it, I would ask that that item be made available to us. This protocol is undertaken all the time throughout the country. Have it sent to an expert of our choosing, and we have one in mind out of Chicago, probably the most well-reputed microscopic analysis shop in the entire country. We'll have them employed to look at it microscopically, make their own determinations. At that point, Mr. Lally, myself, we can agree if, in fact, the results are satisfactory to have it exhaustively tested, but certainly not now. Not after this, as I said, tortured history of this item.
Okay. So am I going to hear from Mr. Lally or Ms. McLaughlin, who wrote Mr. Lally, I'll hear from you.
Your Honor, as it pertains to the hair, so the analyst responds to the garage of the Canton Police Department, labels it as an apparent human hair based on the characteristics that she observes when she removes the item. The item is then taken back to the lab and microscopically analyzed. There are photographs that counsel has from the lab packet that's already been provided. I would submitting any of those photographs to whatever expert they want. I would imagine would concur with Ms. Hartnett's analysis based on those characteristics that it is a human hair. I believe what has just been stated is a complete misrepresentation of what that DNA testing report says. So what the DNA testing report says is that there was no human DNA detected. As the court is well aware, there are essentially 4 steps that are done in a short tandem repeat DNA analysis, the second step being quantitation. So when there is an insufficient amount of a sample, and that's why the root end of a hair is the one that's initially tested for DNA, because you're not getting DNA typically in typical DNA testing from the actual strand of hair, which you're using the root end in the hope that there are some residual skin cells that are left from profile from. That's what no human DNA detected means, which I'm sure counsel is well aware of in its representations to the court to the contrary. So the STR analysis is not done on the root end of the hair because there is an insufficient sample for them to even replicate in that quantitative second step. So the findings from the criminologist or the criminalistics expert as a microscopic evaluation of that particular item and identifying it as a human hair is not incongruous with the finding from the DNA that there was no human DNA detected on that particular item. So as far as this particular item being sent, we're not looking to destroy the item. It's based on the item's size that any further DNA testing is going to exhaust the sample. We're sending it to an outside lab, to an external vendor, and that external vendor does provide for some opportunity for the defendant to send an expert to observe said testing. So there's nothing that's being hidden here or kept from the defendant. All items as far as that microscopic analysis are concerned, lab notes, photographs, everything pertaining to that has already been provided to counsel. All of the testing results have been provided to counsel, and we're asking for it to be, for the court to order or allow or permit it to be sent to this external vendor to conduct this testing and bring in the order before the court because of their.
Yes, blessed Nana. A month before she did this test, she failed her proficiency test. And Wicked, Psych, you forgot one thing too. This was his car. So
Did they say the hair had a root?
no, they couldn't extrapolate enough DNA from the root to replicate the DNA.
But I mean, like, it was
The root end,
like
he
a
said.
root end, because you know how hard it is to get hair out of your head with a root, guys? I mean, come on. Even if it's an accident, it's very difficult for that. So anyways, I was trying to listen and I found that funny. That it
Yeah,
had a
but I find it funny that it's always the defense is just lying all the time. I
I know.
really hate when defense is lying.
Yeah.
They really want to do everything right and do all the testing. And yeah, sadly, that technician, she's not as good as she could have been, but she's great.
She's so stupid.
Lefty,
So stupid.
I'm just
their
gonna.
observation policy and because of the likelihood of the exhaustive nature of the testing.
If the testing is to occur, did they give you a timeline as to, I'm going to hear from you in a minute, Mr. Jackson, I just want to know the answer to this question. Did they give you a timeline as to how quickly that could occur?
I believe 2 months or so is the estimate that I got.
All right. I'll hear you now, Mr. Jackson.
What did he say?
2 months or so.
Quickly that could occur.
I believe 2 months or so is the estimate that I got.
Yeah, so that's 2 years.
I'll hear you now, Mr. Jackson.
This is infuriating.
At the end of the day, all we're asking for is to have the item reviewed microscopically that has nothing to do with any destructive testing whatsoever. It's going to be reviewed microscopically by somebody who actually knows what they're doing. And my problem with Mr. Lowley's response, and I understand why he's responding this way. Well, there was no deception here. We weren't pulling the wool over the court's eyes or counsel's eyes or anybody else's eyes. It looked like a hair. Why didn't they say that? Why didn't they say it looks like a hair as established by our expert who failed her proficiency examination? That would have been a truthful statement. But the statement that they've repeated over and over and over to this court in papers and in affidavits under oath, under penalty of perjury, is the hair has been forensically confirmed. There is no, you can't word salad your way out of that. Forensically confirmed means it's been DNA tested to confirm forensically and scientifically that it is a hair. Then they turn around and try to confirm it forensically, and there is no human DNA detected. I understand that the short tandem repeat testing, the mitochondrial testing, has not been done yet. That's their 11th hour sort of Hail Mary to try to cover themselves for what they've already done, which is to basically defraud the court. And not one, but two, but three, but four different filings. 3 in front of this court, 1 in front of the Court of Appeal. It just doesn't pass the smell test. What we're asking for is very simple. We can address the mitochondrial destructive and exhaustive DNA testing at some point down the road. We want access to that item so that we can confirm whether or not it's even microscopically been properly analyzed. That's all we're asking. And I'll submit.
Can you get me an affidavit from your expert as to why photographs are not sufficient?
I can, and I can, as an officer of the court, I can certainly indicate to the court that this has been done enough. I'm experienced enough to know that they can't do it vis-a-vis even a micro photograph. They have to see the item in person, but I can get a declaration to that effect.
And how the procedure would be conducted and how long it might take. Put all of that in writing for me and I'll consider it when I consider this motion.
Thank you, Your Honor.
All right, so we'll move on to Mr. Yannetti's motion as to why I should change the conditions of release.
Thank you, Your Honor. May it please the court, I appreciate the opportunity to be heard. Your Honor, I stand before you
Oh, James,
because it is in the interest of justice for this court to lower my client's bail to personal recognizance in exchange for Ms. Reed turning in her passport and signing a waiver of rendition. We make this request because there are numerous important changed circumstances that have come to light since bail was last considered and modified. We also make this request because my client's finances continue to be drained and depleted as she struggles to pay the multiple experts she needs to properly defend herself in this case.
So before we go any further, I saved this motion to the end because you indicated that I would have an affidavit from your client as to her finances. I do not have that.
Yes, I did not file that electronically. I had told your clerk.
But I still don't have it now.
I have it in my hand, Your Honor.
So that doesn't help, does it, Mr. Yannetti? I need to read it.
No, I'm happy to pass it up.
So just give it to me and let me read it.
I just need to clarify, these are expenses since the last bail hearing.
All right, so give me a minute before I hear you on
Yes.
this. Has the Commonwealth seen this?
I'm filing it ex parte.
So no, I have not.
Is she gonna?
I don't know who Michael Proctor is.
Neither.
Yes, Gigi. I would say, if you have the time, go back and watch this hearing, because again, the defense sheds a light, puts a light on the prosecution is just not complying with all the things they were told in the last hearing, and now.
All right, so Mr. Lally, Mr.
Any of the results they were
Yannetti,
told
you've
in
seen, I
May or
imagine,
June to get.
in your time as a prosecutor too, you've seen affidavits of indigency.
Yes.
This doesn't give me enough information.
Well,
Doesn't give me enough information under Brangan, doesn't give me enough information at all.
my client has expended multiple, fees to not only experts, but also to lawyers prior to the last date as well, Your Honor. In terms of qualifying as indigent, I would argue that we have a little bit of a different situation here. Generally speaking, somebody qualifies as indigent because they can't afford an attorney, they can't afford any experts at all. That's not what we're saying. What we're saying is there's an overwhelming financial crush with regard to this particular case. And there are also, I should say, many more expenses to come. Many of which have been already discussed by this court with regard to the multiple experts.
Do you want the opportunity to file a proper affidavit under Brangan? This doesn't give me the information that you know that.
We're happy to do that, Your Honor. I would still like to make my argument today.
Okay, you can make I can't make the findings under Brangan,
Right,
Mr.
well,
Yannetti.
but at the end of the day, Your Honor, if it's supplemented by an affidavit, then the court can make a finding at that point.
Okay, I'll hear you since you're here and you're ready, and we're doing a great job with timing. I appreciate counsel all being succinct today.
I appreciate that, Your Honor. As just continuing with my train of thought, the $80,000, our argument is, it's sitting in the Norfolk Superior Court clerk's office now, serving no purpose other than to prohibit my client from using that money to properly defend herself. Your Honor, every time this bail has been discussed regarding this matter, both in Stoughton District Court and in this court, the Commonwealth has consistently maintained that their only justifications for requesting bail are, number one, the potential penalty my client faces, and number two, the nature and circumstances of the case. With regard to both, I'm concentrating my argument on changed circumstances. with regard to the potential penalty in light of
This
the
seems
changed
like
circumstances that have and
he did a-
will be discussed during this argument, in light of what we've learned since the last time bail was modified, we believe, and my client well knows, the potential penalty she faces is nothing. There will be no penalty here because there will be no conviction. There will be no conviction because the evidence establishes her innocence. There is no jury anywhere who will ever vote to convict her for a crime she did not commit.
Get it?
And that leaves us, Your Honor, with a bail argument that relies really exclusively on the nature and circumstances of the case. And the nature and circumstances of the case, as represented by the Commonwealth during its numerous bail arguments regarding this matter, have been shown to be false. It is a fact that the nature and circumstances of this case have completely changed, even since the last time this court modified her bail. The nature and circumstances of this case, in fact, are night and day from what was presented to Judge O'Malley in Stoughton District Court at my client's arraignment there over 19 months ago. At that arraignment, Your Honor, having read only the scant information that the Commonwealth made available to me, it was still immediately clear to me that this case was a tragedy but not a crime. From the very start, with most of the evidence hidden from the defense, the Commonwealth's case against Karen Reed was extremely thin. And from the start, she had no reason to flee, because even without the results of our investigation, her defense was strong. And it was strong because it was based on innocence. By the time I got back to my office that afternoon, I had already begun to learn that this wasn't just a tragedy, and it wasn't just that my client had committed no crime. But shockingly at the time, I learned that somebody else did, in fact, commit a very heinous crime. A friend and colleague of Brian Albert's called me on February 2nd, 2022, only hours after my client was arraigned, and named Brian Albert and his nephew Colin Albert as potential suspects. That tip on day one of this case led us to do the investigation the Commonwealth did not do, the investigation they refused to do. And as my co-counsel has argued today, that investigation revealed that the Commonwealth's investigation was based on one lie after another. And the exposure of those lies is a major change circumstance which justifies lowering my client's bail to personal recognizance. I'd like the court to consider that at the outset of this case, State Trooper Michael Proctor submitted a report stating that Fairview Road in Canton had not been plowed during the early morning hours of January 29th, 2022. He claimed in that report that Michael Trotta at the DPW had told him during a phone call that he had with him after John O'Keefe was killed. We did not take Michael Proctor's word for that, and thank God we didn't, because we learned that was a lie. Rather than take Michael Proctor's word, we instead sent our investigator to speak to Mr. Trotta in February of 2022. He directed us to another man who led us to the plow driver who did plow the street. Our investigator interviewed plow driver Brian Laughlin within a couple of weeks of John O'Keefe's death. Mr. Laughlin told us what he has now told Michael Proctor, now that Proctor finally got around to speaking to him a year and a half after the fact. Shortly after John O'Keefe died, Brian Laughlin told us that he did plow the street in front of 34 Fairview, made a pass by there at 2:30 in the morning on January 29th. And when he passed that house, there was not a lot of snow that had fallen. Visibility was good. The lights were working on his plow. He passed right by the area where John O'Keefe's body would have been if Karen Reed had actually struck him with her vehicle. And he confirmed that at 2:30 a.m., plowing that area, there was no body there. And Mr. Laughlin was firm with Trooper Proctor. There was no body. Yep. And he told him not only was there no body, but if there had been a body there, he would have seen it. He left Michael Proctor in the Commonwealth no wiggle room. The plow driver's testimony should end this case. To put it simply, no body at 2:30 a.m. means Karen Reed is innocent. Forget about all the other evidence that points to her innocence, but this one fact alone prevents the Commonwealth from ever convicting her. No body at 2:30 a.m., she is innocent. But Your Honor, it's not just that he saw no body at 2:30 a.m. After that, he saw a Ford Edge parked right in the area where John O'Keefe's body was later found. Whoever moved that Ford Edge to that location in the early morning hours of January 29th, hours after Karen Reed left Fairview to go home, that person or persons know or knows exactly what happened to John O'Keefe. That mysterious driver and his or her accomplices likely know who beat up and killed John O'Keefe, and that person knows how John O'Keefe received all of the scratch marks and bite marks to his arm. This is all brand new information to you, Your Honor, as you did not have the benefit of any of this exculpatory evidence when you were deciding on an appropriate amount of bail. Frankly, when the Commonwealth relies on the nature and circumstances of the case in order to justify bail being set, those nature and circumstances have changed in such a fundamental and drastic way that I'm surprised the Commonwealth is opposing this motion. When you set bail, you did so in part on a representation by Mr. Lally at my client's arraignment that there was that apparent hair on the rear passenger side quarter panel of my client's Lexus. We now know that Mr. Lally relied on the gross examination performed by a criminalist who failed her proficiency exam in performing gross examinations of evidence. We now know from the Commonwealth's own testing that not only did the hair not belong to John O'Keefe, it turns out it wasn't even a human hair. That is a significant change circumstance from what was represented to you by the Commonwealth, and that would justify lowering her bail. When you last set bail, Your Honor, you had no idea that one of the Commonwealth's main witnesses, Jennifer McCabe, who had been at Brian Albert's house on the night in question and would have had to walk by John O'Keefe's body in the yard if it actually was there at that time, went home and at 2:27 a.m. Googled "Huslong to die in cold." You did not know when you set bail that Jennifer McCabe deleted that Google search. We have stressed to you ever since that our expert not only found that search, but we stand ready to prove beyond a doubt that Jennifer McCabe did it at 2:27 a.m. Our expert is certain. And importantly, the Commonwealth's handpicked expert, Ms. Hyde, confirms that the timestamp was 2:27 a.m., but says that the reason is unknown. This is all new information that you did not have when you have set bail in this case. And it goes without saying, Your Honor, that Jennifer McCabe's Google search, trying to determine just how much time had to pass before John O'Keefe would die in the cold, is completely consistent with her guilt or complicity in this crime and completely consistent with my client's innocence. You did not know this, Your Honor, at any time that you set bail, and this is a changed circumstance justifying a reduction. This is on top of the lies that have been uncovered. Not only did Proctor lie about the plowing of the street, not only did Mr. Lally represent that human hair was found on my client's car when it wasn't, but importantly, Your Honor, you have been lied to by Brian Albert. In opposing our motion to get the animal control records, Mr. Albert's attorney told you that Mr. Albert's dog, Chloe, had no history of attacking human beings. Thank goodness you ordered the records, Your Honor, because we learned that was a lie. And to be clear, I do not believe for a second that Brian Albert's attorney, Greg Henning, would lie to this court. That leaves only one possibility. Brian Albert lied to him. Brian Albert told him that Chloe had never attacked a person. Brian Albert was desperate to keep these records secret from the defense and was willing to lie to keep them secret. The fact that those records have now been brought to court and reveal that Chloe attacked not just one, but two people in the past, sending them both to the hospital, is a major change circumstance. Brian Albert lied, which is powerful evidence of his consciousness of guilt. You should have been able to consider that before you set bail in this case, that information was kept from you. It is now yet another change circumstance that justifies the lowering of Ms. Reed's bail. Now, I expect that the Commonwealth will argue 2 points in opposing this motion, both from lab reports. One, that John O'Keefe's DNA was found on my client's Lexus, and two, that there were microscopic pieces of taillights supposedly found on his clothing. Both of these arguments are red herrings. Regarding his DNA being found on the vehicle, our response is, of course it was found on the vehicle. It would have been shocking if John O'Keefe's DNA were not all over that vehicle, on every part of both the outside and the inside of the vehicle. He was in the vehicle that night, shortly before he was killed. He was around the outside of the vehicle several times that day and night. That vehicle was parked at his house for months. He lived with the owner of that vehicle. It's completely unsurprising that his DNA is on it. That finding does not undercut the new and powerful exculpatory evidence of no body being found in the yard at 2:30 a.m., a Ford Edge being near the yard where the body was later found after 2.
Yes, Goose. No, not really drunk driving. Yeah, well, she might have been drunk. They had been out partying. They're going to her. Her boyfriend is the officer who is dead. They are going to another party at the house of other officers. The state claims that when she backs away from the house, he is behind the car, something like this, with a cocktail glass in hand. She strikes him with the car, which breaks the tail light, which is almost impossible to do. He falls over backwards, hits the back of his head, gets striations on his. I'm showing things you can't see because gets striations on his arm, which they call blunt force trauma. Then all the people who were at the house never saw anything. Even the car that was directly behind the car when she was leaving saw anything. And all of a sudden, in the morning when she wakes up, she calls this girl who was Googling how long to die in the cold, and asked her if she had seen her. And she freaks out, goes over there, and they find him covered in snow, dead. And then all the people are police officers. And when they investigate the scene, they find broken taillight glass on top of the snow that covered the body, not under the body, not at the same layer of snow. And as you can hear, this person is not testifying, is telling that they have witnesses saying they went past. That'll be around 2 hours after Karen Reed should have left the scene and seen nobody. All the people who were at the party in the house never saw anyone laying outside in the snow when they left the party. On the first hearing, the defense claimed that he went into the house, went down in the basement, because they have Apple Fit, I don't know what it's called, Apple Health data showing he went up and down some flights of stairs. He goes down in the basement where he's beat up and attacked by a dog. This dog has mysteriously disappeared. It's living on a farm, because if we tell Jamie that it's buried under the newly poured cement floor, she starts to cry.
I will.
The house with the Alberts, where the Alberts live, they had recently poured a new concrete floor, I believe a year or two before this. They all of a sudden pour a new concrete floor in the basement. They had a pool. They filled up the pool, and then they sold the house. I can understand painting your house before you sell it, but pouring a brand new cement floor in the basement, if you're going to sell the house a couple of years after you just poured a new floor, that doesn't make sense. There's so much circumstantial evidence in this case. And if you've been following along since the beginning, the state really, really wants to turn over all of the evidence so the defense can prepare the case, but the lab is just a bit slow. The dog that never bit anyone has a record of biting people. The dog has disappeared. No one can tell you where the dog went to. I don't know if they gave it away or they sold it, what the story is. But so far, the state claims she backed into him, he fell over in the snow and died. But one of her friends Googled 2 hours after she left the scene, how long to die in the snow. That's just a coincidence. And if you watch the Bradley Young case, it's the coincidence of coincidences. That's why I think this case is a bit sus, because this lady understands still, even if they had an eyewitness passing by saying, we saw nothing, they have broken glass that shows up multiple times after they did the crime scene investigation, or we don't know when it showed up because they don't have a record of finding it. They only have a record of putting it into evidence. There's so many things that's wrong in this case, and that's why this is going to be an interesting case to follow. I'm sorry.
Why are you sorry?
No, she's not kind of hot. She's very hot.
Oh, thanks. It is a little warm in here.
No, Mimsy, because they didn't do the proper paperwork, so that's a big problem. But how can they still? How can this? What I'm questioning, if they have eyewitnesses that are trustworthy, I don't know if they are. I haven't heard him in court saying there was nobody when I was there, and people lied about the snow being plowed on the street. How can she still be charged with this crime, and how can she still be on bail? It's there's so many things that doesn't add up. How do you get scratches on your arms, puncture wounds on your arms from blunt force trauma? I'm an idiot. I'm a trained baker. I'm not a doctor or anything, but I know that blunt force trauma usually means a blunt object, not something that can slash you. I'm sorry. I go into rant sometimes if you're new here.
No, it's exactly.
Yeah, but I
Marks did not look like they were trying to say marks for him
so-
being ran over by the car, and that did
Yeah,
not look like being run over by a car.
and some guy on X told me today, well, it was the underside of the car that made those marks on him.
Oh yeah, I saw
Well,
that.
there's no evidence to him being run over. She backed into him, crashed the tail light, and he fell over. That's what's presented in this case. I have read all the testimony from the people at the house, and no one saw his body when they left the house, which is kind of weird because it wasn't a heavy snow night. Yeah, I should have been a Disney cartoonist. Yeah, I will send it to court. She will be released. This is a motions hearing. Yes, they have several motions. This is the last one. This is a bail motion. No, and this is the big problem. There's so much evidence that tells a totally different story than the state's story. So why can you keep on pressing this? Then they have to make. We just heard the confirmed human hair wasn't human hair, or they couldn't make sure it was a human hair. And again, there's so many things wrong in this case, in my opinion.
Mm-hmm.
2:30 a.m. With Jennifer McCabe Googling how long to die in cold at 2:27 a.m. And then 3 minutes later, Brian Laughlin driving by 34 Fairview and confirming no body there. Regarding the tiny pieces of taillight, for those to have any evidentiary value, you have to trust the person who had custody of John O'Keefe's clothing before it was sent to the lab.
So, Ms. Little, I'm not looking at any, if you show them to the audience before you show them to me, I'm not going to look at them. Okay, please put that down. Mr. Yannetti, do you have chalks for your bail argument? Please put that down. Do you have chalks for your bail argument?
I have one chalk that I was intending to show the court at the
Well,
appropriate time.
I don't need to see a chalk, Mr. Yannetti. You didn't give me sufficient evidence under Commonwealth versus Brangan. So I will hear you because you want to make this statement. So go ahead, but no chalks.
Well, you're right. Just so we're clear, it's not
Did you say
just
chalks
her
or
financial
shots?
status that justifies
can't tell what
reducing the
she's
bail. The thrust of my argument is all with regard to changed circumstances.
I understand that, so I'm going to let you continue. But a very important piece of this is missing. So go ahead with your argument. No chalks, please.
Yeah, and obviously my argument is,
Chuck?
leaving the financial issues aside, the bail should be lowered based on my argument here today that I'm making to this court. I had just stated, Your Honor, that in order for that, the microscopic supposed pieces of taillight to have any evidentiary value, you have to trust who had custody of them, which means that you have to trust Michael Proctor. And I question, how on earth can anyone trust Michael Proctor? I've previously referred to him as being conflicted, which is certainly true, but it actually does not go far enough to describe what he has done in this case just by taking the case. The more appropriate word to describe him is corrupt. Only a corrupt state trooper would agree to investigate a murder case in which a body was found in the yard of a family friend. Only a corrupt state trooper would keep his ties to that family friend hidden. Only a corrupt state trooper would refuse to go inside the home, which featured the body of a dead police officer on its lawn. Only a corrupt state trooper would write in his report that a street had not been plowed when it had. It was the corrupt Michael Proctor who took custody of John O'Keefe's clothing, and that clothing was not submitted to the lab until several weeks after Michael Proctor seized it. You, I believe, have seen the chalk, Your Honor. That chalk shows that Michael Proctor is at the hospital. John O'Keefe's body is on a hospital bed. You see Michael Proctor's feet, and at the bottom of his feet, you see a pile of John O'Keefe's clothing, unattended, sloppily, thrown on the floor.
What?
That's the care with which Michael Proctor treated what they now claim.
If you go back and see the chalk she's presenting, 134.
Who is this Michael Proctor person again?
That's the lead investigator.
Okay.
Who is friends with the Alberts. And the clothes is thrown on the floor. I can do this because I'm smart. Here, and this is supposedly Michael Proctor, the investigator, who didn't enter the house to see anything, who lied about the snow, the road being plowed. But please, the people who has followed this more closely, the judge is also tied into the Alberts or the Proctors in some way. So why she's not recused is I don't get that either.
Yeah, that's weird.
Proctor had seized my client's Lexus and therefore seized pieces of the taillight. And you should consider how he treated the evidence afterward as well, in terms of...
Oh, if you're new here, there is a video where she backs out of a garage. That could be the time the tail light is broken because there's a bollard or something behind her.
That's what they're saying. That's when it happened.
Yeah.
Is because the video shows her and she hit his car when she was backing up. And this is when she was going to look for him.
Yeah.
So this is well after. Yeah.
Yeah. And again, pieces of this taillight shows up at a later date. That's shoddy police work or it's a coincidence of coincidences. And again, everyone is connected to police in some fashion. Welcome back, Farrell.
Hey, Farrell.
Not sending it to the lab until March of 2022. He had it for weeks. Michael Proctor's mother has described the Albert family as the Proctor's second family. Michael Proctor told witnesses who showed up to testify before the grand jury that Brian Albert is the salt of the earth. Michael Proctor's wife has posted about how much they love Colin Albert. The Proctors have constantly been photographed with the Alberts going back over a decade. We've shown that Michael Proctor's in a wedding party with Colin Albert. Colin Albert was the ring bearer at Michael Proctor's sister's wedding. It's so clear that Michael Proctor was both conflicted and corrupt. He had every reason to sprinkle tiny pieces of taillight that he had seized into the clothing that he alone took, so that the lab would later find it weeks later, and sure enough, they did. And this supposed discovery does not undercut the fact that Jennifer McCabe Googled how long to die in the cold at 2:27 a.m., and Brian Loughran went by and saw no body outside that house 3 minutes later. So,
sorry for all the breaks. Ghosty, there are also some claims that this Albert fella might have been a bit shady and that the deceased, he didn't want to play along, let's say it that way. And that's why he might have been beaten up in the basement and thrown out into the snow. We don't have any evidence of that so far presented, but it's a rumor.
Legally, you have all the support you need to release my client on personal recognizance. There's also a practical side to this, which gets into the financial issues, Your Honor, and I'm almost concluding my argument here. You've seen my client's medical expenses in the past. You've been aware of her loss of income. You've also been aware of the numerous experts, witnesses, investigators we've had to retain to do the job that the Commonwealth either failed or refused to do. Those expenses continue to mount. She has not asked this court for a dime to pay for any of those expenses. We're now approaching a trial date, which we will request today. Those expenses continue to mount and indeed will skyrocket. She cannot afford to skimp on these experts. The stakes are too high. She needs every dollar she can to keep going, and $80,000 is a lot of money that will go a long way toward supporting her defense. To make it clear, Your Honor, we are not making this request without offering something in return.
It's the father.
I would submit there's nobody in this courtroom who believes my client
This is
is
her
a flight
father.
risk. Given the national publicity that this case has generated, which I submit will only intensify as we approach a trial date, my client is one of the most recognizable criminal defendants in America. Where on earth would she go, even if she wanted to go somewhere? But she's not going anywhere. Her family's here, her doctors are here, and given the strength of her defense, as illustrated by the changed circumstances we've discussed, she has every incentive to fight this case and no incentive to flee. She's made every court appearance and has invested herself 100% into this case, financially, emotionally, and intellectually. But if there's any concern at all, Your Honor, my client will dispel those concerns by turning in her passport. I have it. She's ready to give this to the probation department. She's ready to sign a waiver of rendition, any waiver of rendition the court would desire. So on this issue, she's really figuratively putting her money where her mouth is. Giving her passport and a waiver of rendition is far more valuable to this court in terms of assuring her appearance in court than $80,000 is. But that $80,000 is more valuable to her because she desperately needs it to defend herself. So for these reasons, Your Honor, I ask that you help us to level the playing field here. The Commonwealth
I'm not
has
sure. I think the
unlimited
family's the ones
resources. My
on the
client
first
does
row.
not. I ask that you release her on recognizance and give her the tools she needs to fight this case.
All right, thank you. Do you want time to provide that affidavit to me?
I'd be happy to do that, Your Honor.
How quickly can you do it?
We have 1 week.
Okay,
Thank you.
yes. Mr. Lally?
Just very briefly, Your Honor. The Commonwealth just requests that the bail remain the same. There's no change in circumstances of the facts, and I use that term loosely as Mr. Yannetti was recounting for the court. Notably absent from his motion in regard to the apparent hair, which I've gone into great detail to explain. I won't bore the court with that explanation again. But what it leaves out is, again, yes, as counsel was alluding to, there were 2 items that were tested for DNA, one of which being the taillight housing. Just to be clear, the taillight that was within the defendant's vehicle, which was then compared to the DNA of the victim, Mr. O'Keefe, and that there was a significant statistical probability of comparison between Mr. O'Keefe to a number followed by 30 zeros that Mr. O'Keefe's DNA was on the taillight. The same taillight that was broken when the defendant struck Mr. O'Keefe with her vehicle. Now, as far as what counsel states as Mr. Loughran's testimony goes into great detail in the motion as well. What he leaves out, though, is that all these insinuations that the Ford Edge somehow belongs to the Alberts or is Brian Albert's Ford Edge or something to that effect. What he leaves out from that interview with Mr. Loughran is that Mr. Loughran specifically says that Ford Edge is not Brian Albert's Ford Edge. Another sort of interesting...
He didn't say that.
...issue in relation to the affidavit from the investigator in regards to seeing that Ford Edge and his label as such is that the investigator essentially takes Mr. Loughran out to the parking lot, points to a Ford Edge, and essentially says, is that it? Somewhat suggestive identification of that particular vehicle, the Commonwealth would suggest. There is simply no evidence of Trooper Proctor having a close connection with the homeowners. There is simply no evidence, whereas I guess now it's being positioned that he was sprinkling tiny pieces of a taillight, pieces that I described to the court earlier as less than.
The guy whose mom called the Alberts the Proctor's second family, the guy who was a ring bearer at Albert's sister's wedding, has no close ties to the Alberts.
And the
That's why they
freaking
left.
gallery went crazy. That's what I was saying. Like, what happened? Did they?
Yeah, that's why they left, because he has nothing, no connections to them at all. Nothing.
Bullshit. Whatever.
They have pictures of them together for more than 10 years.
They're so. Oh my God, they are. Oh my God.
And this guy,
slimy.
just let it go, fella. Take the bus, take it off, get the.
Slimy.
It's just so stupid, and everyone can see, the entire courtroom can see. Everyone, we have 40 people right here, right now. Everyone can see that dog just won't hunt. It's if they had 10 years of photos together. If he was a ring bearer, just don't be stupid, because you're gonna look a fool.
Mm-hmm.
Sorry, 1/16 of an inch that were embedded within Mr. O'Keefe's clothing. I'm not going to go over again and again the issue as far as Ms. McCabe's search on her phone. The court has been provided numerous reports from forensic experts disputing whatever Mr. Green's findings are. Counsel seems to want to choose or pick and choose as they do with each particular piece of evidence or each report as to what they want to highlight. But the conclusions from Ms. Hyde's report are clear, that from her analysis of that search was conducted respectively at 6:23 a.m. and 6:24 a.m. It is not a mystery as to when that search was conducted or why that search was conducted. It was conducted by Ms. McCabe at the bequest of the defendant. As far as anything pertaining to Ms. Reed's financial resources, again, those were filed ex parte and as the court, so I really can't speak to those. All I can speak to as far as financial resources is this case was initially arraigned in the Southern District Court. The court set a cash bail of $50,000. The defendant posted that within minutes. The defendant was then arraigned in this court. The court set a cash bail of $100,000 initially at arraignment in June of 2022. That bail was posted within minutes. If the court is inclined to...
Yes. Allegedly, the reason the woman searched how long to die in the cold, 3.5 hours before they found the body, according to her Google search history, was because the defendant 3.5 hours later asked her to please do that. I'm not sure. I'm not an internet guy. I'm a monkey puss in buttons, as I always say. And they can't really explain why Google made... There must have been a glitch in Google that day, because Google runs on a specific time set all over the world. It's probably British mean time as a standard. So why would her phone show she did the search hours before they found the body? I would really like to hear the technical expert come in and tell her. And the defense said they had confirmed with the police's expert that the timestamp was 2:36, I believe it was. The body is found around 6:24, 23 in the morning. And she couldn't explain why Google had made a different timestamp. Google doesn't make mistakes with timestamps.
And it's like I said before, it's just too convenient for that particular search in that particular situation.
It's this is I'm how this case can still go on, and if she's not granted a reduction in her bail, alone the fact that they are claiming Google made a mistake. Google doesn't make mistakes because everything has to sync up on Google. Then every search that day would have had a wrong timestamp. Something would have happened dramatically gone wrong at Google to get a 4-hour delay, because you use the internet to buy stocks. And if Google's clock is off by 4 hours, how do you prove that you bought the stocks at that time? This is infuriating. He totally agrees that the timestamp says to something, but he claims that it's just a mistake. It was really 4 hours later. This is just I can take shenanigans in a trial, but this is just stupid that he claims. Well, Google makes a lot of mistakes, but something like this you would know about if Google had a night where everything, because all the transactions and stuff like that goes over the internet, they would have been had to be addressed again, so you had all the timestamps right. Yeah, Google uses atomic clocks because they have to make sure everything is run on tight schedule. Yeah, and maybe you can throw around the phone and it makes another timestamp. It's one of the Alberts got a 2-year for a hit and run. Well, it's nice to know. It's nice to know a judge.
Mm-hmm.
Yeah, we all know this is a crock of shit, but there's still a lady sitting after 13 months, I believe it is, and waiting for a trial, where she has to listen to this, I'm sorry, idiot claiming Google made a mistake.
And saying, oh, we're still testing all this evidence. Sorry.
Google could probably make mistakes, but a timestamp is something that would be worldwide, because Google covers worldwide, and we would have known about everything. Whenever our payment system goes down, we would know it. And Google runs a lot of those transactions, so you would have known if their clock was off. Yeah, it'll be 2 years in January. And the judge knows the brother-in-law of a person that should be a suspect. Well, that's a coincidence. She seems like she had a bit of a chip on the shoulder, and if she knows the Google has a lot more than clock. I know that, but to claim that Google magically on her, when she did the search in their search engine, magically it was 3 to 4 hours. There was a 3 to 4 hours discrepancy. I could get it if it's because police are stupid, as they all sometimes I have to watch out, because when you download in Cellbrite, sometimes you download it in British Mean Time, because that's the standard on YouTube, on Google. When you download those things, they will come out in what Americans call military time, and what normal people call a 24-hour clock. And then you have to do the math. I have to do every time I put up a stream. There's a bit of time zones, time differences. I could understand you could misread that and say, "Oh, this timestamp says." Now I have to think Massachusetts. That's 5. This says 10 in the morning, and the search happened at 5. Well, that's because you have to factor in that British Mean Time is 5 hours ahead of Eastern Standard Time. But Google doesn't have a 3-hour timestamp problem. That's just too convenient. Sorry.
Reduce the cash bail. I don't think it's of much moment to the defendant, Ms. Reed. But if it were, I would ask that some additional conditions be set in place, similar to what I had asked for previously on February date. If the court were inclined, I would concur with surrendering her passport. I would concur with executing a waiver of rendition. And I would ask that there be an additional order, the defendant be ordered to remain alcohol-free, subject to random testing with a SCRAM device, based on the nature and circumstances and based on the indictment she faces in this court. Thank you.
Okay,
If I may respond briefly to 2 points,
Sorry.
Judge.
okay.
First, with regard to the DNA being a match or a presumed match of John O'Keefe, what Mr. Lally didn't tell you is that that sample was a mixture of John O'Keefe and 2 unknown people. So I don't know if the Commonwealth is changing its theory again to say that my client struck John O'Keefe and 2 other people, and the other 2 people somehow got away. But that doesn't make a whole lot of sense. The second thing is, with regard to the Ford Edge that Brian Laughlin saw outside that property, I would say 2 things. Number one, assume it was not Brian Albert's Ford Edge. It doesn't matter because there was somebody there outside the property where the body was found after 2:30 a.m. They would have either seen or not seen a body and known or not known that there was a body there. But finally, with regard to that point, Mr. Laughlin was clear that it was not Brian Albert's Ford Edge. What he did not tell you, what Mr. Lally did not tell you is there's another member of the Albert family that has a Ford Edge, and that's Colin Albert.
So, Mr. Yannetti, I need that affidavit by next Friday, so I'll take this motion
Thank
under
you.
advisement.
Appreciate it.
All right, so I said at the beginning that we need to set dates, and it's been mentioned that there have been a couple of pretrial conference dates. There have, but counsel have not complied with the Superior Court standing order that we need to get back on track. So Superior Court standing order 2-86, so we need to set some dates. And counsel has to comply with Rule 11 of the Mass Rules of Criminal Procedure regarding the pretrial conference. So I'm going to give you a date for you to fill out the pretrial conference report and do everything that you're supposed to do pursuant to Rule 11. We need that before we can go any further. And in that report, you need to outline dates for filing of motions. So I have some suggested dates, given that we were able to work out the discovery issues today. So I think all non-evidentiary motions in this case must be filed by November 16th. I don't want any more piecemeal Rule 17 motions. If there are piecemeal Rule 17 motions, you need to put in the affidavit why those weren't handled when they're supposed to be. I would like January 5th for filing all evidentiary motions. And February 15th for a pretrial hearing, final pretrial hearing. And you say that you have proposed trial dates. What are your proposed trial dates?
Your Honor, it would be the defense request, and we're open to the specific date, but we would like a trial date in March 2024.
Okay, that's great.
Early March would be better if it's
Write
available.
these down.
So we have a trial that's starting in January, a retrial that last time took 6 weeks. So I think mid-March would be better for us.
Okay.
Jim, can you suggest dates?
Yeah, how is March 12th? 12 or 19?
12 would work.
Is the court's preference, just going by what Mr. McCollum said, to start on Tuesday?
Yes, we typically do
Yeah,
Tuesday.
because civil and panels on Mondays.
Makes perfect sense.
Yeah.
Does that work for the Commonwealth as well, March
March
12th?
12th, yes.
That's fine, Your
So, as a result of that, can we have a final pretrial conference sometime the end of February? Maybe 26, 27, 28 in that time frame? Is that okay? Is that week good? for you guys?
We're
Oh, I'm
just-
sorry, I'm sorry. Yeah, go ahead.
It's good for me. I just want to make sure it's good for my.
Yeah. No, fine.
We do the 26th, would that be available?
Yep. That's a Monday, we can do that.
Is that-
That'll be at 2 p.m.
I was just going to ask, sorry.
Yeah, and we expect you to exchange motions and eliminate any potential voir dire questions, as whether or not you want to do a panel voir dire.
Right.
So that we can talk about it on the,
So those, and the dates that I gave you, November 16th and January 5th, those are out-of-court dates. Have all your motions filed on those dates. And give me a realistic date that you all can file your pretrial conference report. I suggest it be around
This is
November
his
3rd.
family. Justice for JJ. Why are they allowed to wear those in court? They won't be when the jury is there.
Maybe we'll do November 3rd. Does November 3rd actually work?
can you do November 3rd?
Yeah, November 3 is fine, Judge.
All right.
So that's just the final pretrial conference and that's that.
Yes.
Yeah.
So we currently do not have an in-person date until we see about those filing of motions from January 5th.
Does it make sense to have an in-person date of November 3rd, Your Honor?
It does if you want, but you've talked about the expenses. It doesn't make any sense to fly people out here if it's unnecessary.
My suggestion is that the Jesus witness case, if you'd like to have a person hearing on November 3rd.
Okay.
If there's any T's that need to be crossed, I's that need to be dotted.
I'm not available that day,
Okay?
that week, actually. I'm on trial.
Can
Different
we pick a date the next week?
No, it's the,
6,
I believe
7,
it's the family of the deceased.
8 or 10?
10, it says Veterans Day observed, but I don't know. No, Jim, let's actually do the following week. Let's do the 16th.
Court date. We can't do the 3rd.
Oh, you can't do the 3rd, I'm
Yeah,
sorry.
no.
All non-evidentiary motions.
This is just
My counsel makes a good point. I'm sorry.
I know.
this is just figuring out
Yeah.
dates.
Can do the following week.
December?
Fine.
Jim, I'm going to keep everything. Jimmy, that would be great. If I could see you in a bit.
Well, that was that. I just start a few things because there might have come something important in. Well, Alexandra, Google HQ is in Cali, yeah, but most of everything electronically is set up to follow Greenwich Mean Time, because that's the standard. So it wouldn't have any importance in this. Yeah, clapping. There's a lot of family members for the defendant. And Alexandra, never mind. I'm always glad to see you here. And Cindy Lou Woo Hoo. So the prosecution table is at the front of the courtroom and defense is behind. That's not very fair setup, in my opinion.
It is a little weird, but
I think Mass has it right here. I would rather that I could watch my opposition than they have to turn around to watch everything. And maybe they're going to change it around when the trial is ongoing. We don't know that. This is just a hearing. There's no jury at the room. So it's not that important today, I would believe. Civilians are wearing white buttons with something written on them. Law enforcement in the audience are in the... Well, everyone is in plain clothes. and the audience. So, but the ones with the buttons are probably his family, the deceased's family.
So
And no,
I didn't really
they-
know. None of them are supporting her at all. I'm taking it.
sorry.
I said I didn't really know, but I said none of them are supporting her at all. I take it.
Of his family,
His family, yeah.
I believe the police have told them all about how bad a person she really are.
I'm sure they have, but it's just like, see it with your own eyes. Don't listen to a bunch of the rumors. See it with your own eyes, because it doesn't look good for the state.
I really have to say, the first hearing made me very suspicious of shenanigans going on in this trial.
Mhm.
I'm really surprised that we are still here after the totally not a dog bite thing. And now you have, even if they try to claim it's Turtle Boy who made up the Plow guy, you still has to have his testimony. You still have a lead prosecutor who is closely befriended to the family at which residence this happened. You have two other people's DNA inside
Mm-hmm.
the light fixing, which he said, well, his DNA was inside this light, so that makes it really, really special. Yeah, but when there are two other people's in there, again, had someone got a little bit of blood and did a little swing by with a finger. It's it's just too much coincidence of coincidences. Oh, and the FBI interviewed the Plow driver too. And how this is allowed to be run by the police when so many police officers are involved in this. Everyone knows someone who is in the police, who's a judge, to me, this is really a bad case. And yeah, they're going to take it to court. But I can't, with the evidence they have produced from the defense, the threshold you need to meet is beyond reasonable doubt. Alone, the marks on his arms, I would love to hear how they can explain that. And
Yeah.
Wicked, I agree with you. This case should be dropped pending further investigation. There are so many parts in this case that just doesn't add up.
I'm still stuck on the house being sold, the basement being redone, the pool being filled in, the dog magically disappearing. I'm stuck on that.
I'm stuck on the blunt force trauma that pierces the skin.
Yeah, I mean, obviously, the injuries do not add up to what they are describing happened to this guy at all. And when somebody's Googling how long does it take to die in the snow, right around the time everything's going on, it's too much of a coincidence for me.
Ghostly, I don't think the FBI have taken over the case yet. They're looking into something, probably because a lot of stink has been raised about this this being an inside job.
Well,
And how this, as Mim says, how this is still a trial with all the evidence that raises doubt about it. But again, if the judge has a summer home close to the Alberts, why is she not stepping down? Just to take away any signs that could be, that she could be in conflict with anything. I really don't get this case, but I'm so happy that so many people stopped by. A lot of new people were here today. Thank you all for participating in the chat. If it's the first time you're here, please like, subscribe, do all the YouTube things we have to beg for, because it's kind of the law on YouTube. Jamie don't want to back
No,
for
I had
anything.
to cough. I didn't want to be on camera.
And again, thank you so much for showing up. If yeah, now you know me. I'm a rambling monkey pushing button who draws funny pictures. Jamie is my lovely sidekick with the loveliest lashes you can find on the internet. So if you want to see more of us, we do a little Saturday thing we call Stab Your Day, because sometimes we talk about crimes. Most of the time we just we go live at around 9 a.m. on Saturdays, and we just ramble about nothing for 90 minutes, having fun, having a lot of fun people in chat who makes fun of us. So if that's in your wheelhouse, please stop by tomorrow at 9 a.m. Thank you, Jamie. Jamie is the only reason that I'm close to 600 subscribers. It's been a really, really good time the last couple of months. So
Please,
yeah.
it's your humor and your pictures and your commentary. Everyone loves you.
I would like you have said it's my body, but okay.
It's your
3
beautiful.
out of 4 is okay. And Gladys, you are new here. I will. I'm trying to cover the cases as much as I can. I have a lot of cases rolling around. I started coverage of. I even do some coverage of some strange Danish cases, but we don't have pictures in those. And again, I don't take sides. I try to watch the evidence. But this trial, there's so much evidence pointing in all other directions than this young lady. So I try to be fair, and even if it's an a-hole who's understand. But if you like the kind of stuff I do, please come back. Monday we'll go back to the Cara Ritali case, the woman who allegedly killed her wife. There's a lot of shenanigans in that trial too. It's the 4th time she's tried in the same case. 2 times it was a hung jury. Then she got convicted. It got overturned in the Supreme Court. So now they're doing it for the 4th time. We're going to start that on Monday at 9 a.m. Eastern if you want to do it. So everyone have fun. Is anyone live we can talk to, send you to? I can't send you to anyone, but I can give you a recommendation of where you could do. Earlier today, I sent, no, the expert is not even on screen, so I won't do that.
No, never mind. It's 5 o'clock.
You can could, if you want some fun and you want to hear the most intelligent person and most interesting guy on the internet, you can go and see Legal Vices. He's having his Friday fun stream, and you can go join Excited Utterance in 30 minutes. But if you go and watch Legal Vices just for the fun of it, because I can't send you to rate anyone, just put in Baker Rate. That makes me so happy. Great success. I won't be emptying all the bottles behind me at 1,000 subscribers, because 1, 2, 3, 4. That's gonna kill me. But if you go over and watch Vices, please just say Baker Rate, because that's, well, Farrell, you don't have to. You're so mean, Farrell. I love you. Everyone, thank you so much for joining us. And we go live again tomorrow at 9 a.m. and then probably take the Sunday off. I love you all, but I love Jamie more. See you later.